Opening the subcommittee work session on House Bill 257. House Bill 257, establishing the crime of criminal neglect of a child. The bill as written, it's a rather short bill, so I'm gonna read the bill as written, and then we're gonna discuss a couple of different ideas we have from members. So the short title is going to be listed as Charlotte's Law. I don't recall the testimony about that. We're going to have to ask why that is. I'm sure there's a, it's what? Oh, the little girl. Okay. All right. Now I know who that is. A person is guilty of criminal neglect of a child if the person is responsible for a child's welfare and through his or her action or failure to take action for reasons other than poverty, negligently fails to provide any of the following so as to seriously endanger the physical, mental, or emotional health of the child. And we have necessary care, necessary food, necessary clothing, necessary medical care, necessary shelter. The protection from ingestion. Oh, that's okay. We started the wrong bill, but we're just going to keep going because we roll like that. The protection from ingestion or exposure of distribution of manufacture of controlled drugs. For the purposes of this section, child means a person under the age of 18. Necessary care means that it is vital to the needs of a child's physical, emotional, or mental health based on all the facts and circumstances bearing on the child's need for care, including the child's age, child's physical, mental, or emotional condition, and any special needs of the child. A person who violates paragraph 1 is guilty of a Class A felony if the neglect resulted in the child's death, a Class B felony if neglect resulted in the child's bodily injury to the child, or the child becomes a victim of any offense under RSA Chapter 632A or 649A as a consequence of neglect. A Class B felony if the actor has twice before been convicted of an offense under this section. Class A misdemeanor for any other violation. Extended term of imprisonment. Amend RSA 651:6, i.e., to read as follows: has committed or attempted to commit any of these crimes defined in RSA 631 or 639:3A against a person under 13 years of age. So, a couple of issues that were discussed during the hearing. Some questions we heard from the committee were, first of all, the necessity for the Class A felony, or I believe it was Class B felony for the second one. And I'll open it up for discussion. Representative Scheer, did you want to discuss your proposal?
Um, I'm very appreciative of the county attorneys bringing this bill. I understand what the issue that they're struggling with. And more broadly, I think the issue is when do we have the criminal justice system step in and really take over dealing with some parents that very likely are already involved in DCYF process, and you know, which can result, that process can result in termination of parental rights. That's kind of the back end, most dramatic result from the DCYF process. We all appreciate that DCYF is not by their doing underfunded, and may not be able to address as many families as they would like to. That's on the one side, and I think the issues and the testimony we heard are, it's very important to address this issue. What I heard from the county attorneys is why they decided to bring this bill, 257, is that they weren't able to work with the child endangerment statute, which is 639.3. And the reason they weren't able to work with it in many cases is because The statute read like this: a person is guilty of endangering the welfare of a child or incompetent if he knowingly endangers the welfare of a child under 18 years old of an incompetent person by purposely violating a duty of care. And then it goes on. They said the word purposely there, which means you intend the result of your conduct. That's your goal. That's the word purposely. That makes it very difficult to prove in these cases. My tentative proposal is to accommodate their struggle with 639.3 and change that word purposely to knowingly, which makes it much more workable for them to prove cases. A knowingly statute, knowingly is defined as they know that their conduct will result in the consequences. So I think that broadens the scope of 639.3, and it relieves us of the difficulties of sorting through a lot of the language of HB 257, which, while well intended, is really there's a lot of things that are undefined. I guess the final thing I would say is I'm leery of the criminal justice system being able, given the limits of its resources and its tools, to do better in reaching the parents we want to reach than DCYF does. The criminal justice system, you know, they have fines, they have the threat of jail, they have probation. But, you know, what we really want to do is stop these parents from engaging in this kind of behavior. And what would happen if they were on probation based on a criminal charge is a probation officer would say, you got to go see social services. If you don't do that, we're going to impose your jail sentence. I mean, that's the tool, the best tool they have to try and remedy the conduct of the parents. But we all know the social services in New Hampshire, putting aside DCYF to manage this, are almost non-existent. So though I fully appreciate what we're trying to do with 257, I think this is a better way to get there for now.
Have you addressed this with the county attorney at all? Have you had a chance to talk to them?
No, and I can do that.
Is anyone here from the county attorney's office? Beth, would you like to?
This subcommittee for this bill is noticed in the calendar for 11.
Yeah, we
and the
flip-flop.
stakeholders are coming, so I don't
Oh, they
know.
are coming?
I didn't know, so I wasn't sure.
Okay. You know what I'm going to do? I'm going to recess this until 11 because there's people coming. And I will open the subcommittee work session on House Bill 405. And that bill is regarding the sex trafficking storefront in New Hampshire. Is that correct?
Yep.
Okay, so this is not what we were talking about earlier.
So that's one.
This
Yeah,
is
this is a
massage
different one.
parlors.
Yeah, that's the one
Yeah.
that, there's some bills in
Yeah.
there.
Yeah. I think that I think we came to a conclusion that we don't want to study this anymore. We want to actually pass a law. Is there anyone here today specifically for this law? Would you like to address all of you? Anyone who wants to come on up? What we're interested in right now is we want to write a law to, so we're all set with the study committee. So any language that you have, we'd love to hear it.
Good morning, Representative and Chairman Roy. Thank you for allowing me to speak on this matter. Charles Foote from Derry, representing Rockingham 13. I am a state rep, but also a town councilor in that town. As you know, we testified before you last week. This is a real concern in Derry and statewide, and as you heard from other testimony, this is an international issue. And sorry, that's my medical alarm going off. And we also concur this is a bill that needs to have some affirmative action sooner than later. As you heard last week, there's the communities around us, the states around us in New England make it a Class B felony, I believe, for anyone who harbors these or knowingly allows these businesses to happen. So that's what I would encourage this committee to do, is make an amendment so we can pass that law and make this a felony so we can really put a stop to this. And I'll leave it at that. That's you have all the information before you, and I just
What's going on in your community? What are you getting for feedback from law enforcement as far as why they are not able to do anything right now?
so the basically because there's really nothing that sticks. You know, they go in there and it's such a low level offense, and I'm paraphrasing.
Yeah, that's fine.
Coincidentally, I do have a meeting with the chief upcoming and the town administrator about this. I did speak with Homeland Security agents last week as well.
Yeah.
And essentially, it's just there's not enough teeth in it to have anything stick, and it's basically it's a misdemeanor crime level offense, and these actors, they just keep moving around from location to location. The girls, from what I'm aware of, the ladies involved in this business, they get cycled out every 10 days or so. So it's hard to hit a moving target, essentially.
Yeah, yeah.
So that's the nuts and bolts of it. It's just there's not enough teeth to have anything stick to make this worthwhile going in. And I'll let the town administrator address it further if he has any more technical aspect
Yeah.
to it. But that's what it comes down to.
There has been some discussion in the past about maybe empowering the OPLC to be able to go in under the massage licensing and do SNAP unannounced inspections. Which would the problem with that is when you do a regulatory inspection and you use it for the purpose of getting law enforcement information, the regulatory then becomes the agent of the state, and they are, for all intents and purposes, law enforcement, and they need a search warrant. So it's really difficult to use one to get to the other. But we'll take that under advisement. We're going to come up with something.
Right. So I'd also, Representative Jody Nelson and I met with OPLC last year.
Mm-hmm.
And, basically the understaffing and the amount of volume of what they deal with.
Yeah.
And this basically was outside of that purview. So again, they said essentially there's nothing we can really do. And with these parlors opening up under Body Works, which was a license out of New York, it does become a licensing issue because is it a reciprocity issue? So how does the state or the town regulate those coming in?
Yeah.
Like who oversees that?
Yeah.
So that's a big concern.
Yeah. And then we end up having to create a whole new bureaucracy of OPLC.
Right. So
Yeah.
it seems like, for the layperson, oh, this is an easy fix.
Yeah, but it's not.
It's really not. It's really convoluted, and that we need to hone in on it and make this a serious offense and crack down on it.
Okay.
So I thank you for your time.
I appreciate it. Thank you. Would you like to speak to the town administrator? You don't have to, only if you want to. Representative Shea, did you have a comment or?
I was wondering, would it be, I think it'd be very useful. I remember from last week, the testimony from the two people from Homeland Security, that they were very committed to taking action and not
Yeah.
having a study committee. And, I suggest it might be very useful if you all were to get together with the Homeland Security people and talk through exactly what you want to propose, so there's coordination there. I think that would.
We can speak to that. We can speak to that. Yeah.
Okay.
I was just going to say, I think they literally had a list of suggestions, so that would be super helpful.
Good morning. I'm Dave Karen, the town administrator in Derry. Thank you for your time working on HB 405. Speaking with Chief Fioli, the frustration is that there are language barriers and refusal to cooperate for the workers who are actually operating in these massage parlors. So we think there's really a three-prong approach. One is that a statewide database for licensure, no reciprocity, and that if a female works in one, she has to be licensed to that location only. Because what we're finding that jumping from community to community, so doing it on an individual community basis has not been very effective. Also, what's really be effective is what Pamela has proposed here, is to have the landlord assume some responsibility for who's occupying their premises. We found that's been very successful in other states and has really, really slowed down the proliferation of these activities.
I would assume once you have some skin in the game as far as potentially losing some real estate, you're going to be much more careful about what goes on in your,
And at the felony level, it tends to get the landlord's attention.
yeah. Okay, great. Thank you for that input.
Thank you.
Yeah. And congratulations on your police department being accredited. One of the first one in the state. Yeah. Go ahead, Pam.
Good morning. So we're from the coalition. So page 2, I think, is really what speaks to of the handout I gave you, and can email copies to the rest of the folks here. Page 2, I think, really speaks to that taking action component as something that we could do this year that immediately would speak to what has been brought forward this morning. We weren't sure if there was still sort of if having a study commission still could help move or continue the conversation to have further legislative action. But this, yeah. So I think we just didn't know what the committee would be most favorable or what would be most strategic in terms of continuing ensuring that we really address this issue. I think, as the town administrator stated, it really helps when you have both a law enforcement but also a regulatory approach, and I think that's something we should continue to explore. I know in the past, and I have copies of the bills from a couple of years ago, there's been the effort for the licensure piece. I think while I agree or understand where we don't want to make the OPLC another law enforcement agency, the ability to regulate and just be able to go in and say, hey, you're not in compliance with all of these health codes. The people in this don't actually have licenses, can help add a level of ensuring that all of these businesses are doing what they're supposed to be doing, which is legitimate massage practices. And so I think right now, these illicit businesses are only identified through complaints and reports to law enforcement and sometimes to the OPLC, but action cannot be taken unless those concerns are raised, is my understanding. But so page 2 really speaks to an area in the prostitution statute that we can really focus on the business practice. And, I understand it may not have written it correct fully, but this was my attempt.
You mean in legalese?
In legalese, my non-existent law degree, but I did my very best to highlight the main issue, which is paragraph E, which is currently a misdemeanor. If we raised it to a felony, and then I did note that there is already a clause about involving minors, and so I did bring that in if there was interest to also make that as more severe penalty, again, to give some more teeth, or we could just make it a felony and leave it at that. So I think there's some flexibility here, but this is really what's been identified as the key way to address it. It's not, creating a lot of felonies within the prostitution statute. It's really narrowing in on that one piece that's been really challenging.
Okay, a couple things. I think that we can do two things. So I think I like the idea of creating a commission, not a committee, a commission, and have it be broad so that it covers human trafficking, period, not just necessarily in this aspect, but in all aspects, because we're dealing with it on several levels. We're dealing with immigration, we're dealing with it on missing children, we're dealing with it in this. And I think that it's worthy of having an ongoing commission that can keep track of the various changes going on in federal and state law and intelligence that's coming in, so that we're nimble enough to change our statutes as we need to. So I think that that's okay to do both.
I think we would definitely I think part of the reason we wanted to be hyper focused on this particular issue is because there are a lot of different stakeholders and agencies that are trying to address it from multiple angles. And the task force, so New Hampshire does already have a task force that is multidisciplinary and has, Homeland Security folks, prosecutors, crisis center advocates, and so on. So I just don't want to have parallel work from what the task force is already doing to address these things, but I hear what you're saying and understand. Yeah.
Does the task force have anyone from the legislature involved in it?
Not currently.
No, but
No. So I think that's a
do you want to speak to how they could join?
sure.
Yeah, it would be helpful just because we don't know what's going on. So then we hear.
Yeah, I think that makes a lot of sense. The task force is kind of in the process of restructuring. I don't know how much members of this committee are aware. The task force, as of this budget period, is state funded rather than funded by federal grants. And as part of that process, the Attorney General commissioned a needs assessment, a statewide needs assessment, which has just completed. So their office has seen the results of that. We have not yet as a task force. So we know we will likely be changing structure. We don't quite know how yet, but we are certainly hoping for more buy-in from stakeholders at the state level now that we are a fully state funded.
And on top of that, Meg and other members of the task force have been working with the AG's office to create a human trafficking protocol in the state so that everyone could follow when addressing these cases. So I think the hesitancy is not because we don't support looking into this issue, but we know that there's a few moving pieces right now that might lend itself to helping shape future legislation on a larger, on a bigger picture.
I'm just trying to balance the difference between a commission and a committee.
Got it.
And a commission is an ongoing thing. So if I just hyper focus it on this one issue, it's kind of that's not to make light of it, but it's a small issue for
Got it.
an ongoing thing that has no end. So I could do a commission with an end date of 2 years or something like that if we're going to
Yeah.
hyper focus it.
And then I think, because I think that could help leverage some of the conversations that are already happening within the task force and these other agencies. And
I have a question about massage licensing. And I know it's probably not your expertise, but maybe you've picked it up in dealing with this. Each of the individual massage therapists are supposed to be licensed, correct?
I believe that's correct, Pamela. Yes, but the business overall is not.
Yes,
Yeah.
that is.
that's correct. And that's the kind of the crux of the issue is that in New Hampshire, some professions have to be both individually licensed and then the establishment is licensed. But in New Hampshire, the establishment isn't, but individuals are for massage and other body works. And so that's sort of what we're trying to kind of regulate a little bit because sometimes the people who are operating in these illicit businesses aren't actually the ones that are licensed. And then it doesn't.
Well, that's what I'm assuming. I
Yeah.
understand that it's not an easy license to get or maintain. I think they have
Right.
to take continuing ed classes and all kinds of things. So I'm assuming that these people that are in here that are rotating around aren't licensed therapists. So is OPLC unable to go in there and check their licenses? Or the local health department? Or-
Yeah, I could definitely. I know they've testified in the past on the establishment piece. So I could look back at their past testimony just to see where they're coming from that angle. But I think there's a little bit of a disconnect about actually being able to go in and regulate the business and versus the license of the individuals.
Representative Rhodes, did you have something to add to this? Because I know you looked at this and worked on this before.
Thank you, Mr. Chairman. I think I do. So, okay, so in the committee, when we heard the comment that was made that, well, maybe a landlord could say, if you don't, basically saying that you have to let them in or else we're going to terminate your lease, whatever, that would be like a no starter, right? A landlord can't say what the tenant has to do if it's unconstitutional. You just can't let somebody come into your business, you're going to lose your lease. However, so if the employees are supposed to be licensed and have a license on the wall that they're identified as that particular person, right? If the state has the ability to go in and do a spot check per se, which now they don't have the ability to do that, then that would be one thing, right? If there's 20 people here and there's only 7 people's names up on the wall, there's clearly an issue right there.
Right.
And then additionally, if it was where, all right, you're licensed for this location, not this location, right? So if it's the thought of, well, I'm just going to pack up in the middle of the night and go to another location because they're on to me, for lack of a better word, that would prevent that, because you're only allowed to be right here. And if you want to go there, then that establishment would have to be inspected per se before it could be opened, right? Would that be like the general idea of, and then by the time you catch on, they pack up and they're gone, or they're shipped someplace else, right?
Yeah, and I think I just wanted to circle back to that, you know, as far as the individual licensure, I think that comes again back to the issue of then the infraction is on that individual massage therapist who likely is a victim of trafficking. So I think that's a big part of it for us as well.
And so I think part of it is like really holding the business, like the people operating them accountable.
Well, in other words, you can charge the person running the business with hiring unlicensed therapists versus going after the
Right.
unlicensed therapist. And as far as limiting the licenses to geography, that would be problematic, because you can't say you're only licensed in this town. But
Right.
I believe we could enable municipalities to require some type of either licensing or registration for them to operate in the so that their health department could theoretically get involved and go check licenses as well. So there's several levels that we could look at this from. Representative Scher, did you have your question?
One could write a statute that that with language that puts a burden on a landlord. That, you know, one way to do it. I mean, there's cases out there that talks about charging a landlord as an accomplice, and really what matters there is their mental state. So. Yeah, you know, if you could write a statute such that if they were aware of what's going on, that they could be charged as an accomplice. That's really not hard to write. The issue is, would you want to put in that statute an obligation on their part to know what's going on? So that's the soft spot on that. Second, you know, OPLC as a general matter is, and I don't mean this in a negative way, but they're a passive operation. They take licenses away when somebody reports a violation to them. They've never done investigations on their own. They proactively, they just don't. That's not what they've done historically, and God knows they don't have the resources to do that. Last thing, have you all talked to Homeland Security?
Yes, I was just going to circle back to that. Yes. So we work closely on the task force with the Homeland Security officers. They would have liked to be here today. One of them has just started a new chief role in New Durham, so he's busy with that, and the other is on a prearranged vacation. But the second page of what Pamela has provided is really what Task Force Officer Millar was speaking to the most with us, as far as the challenge of this being the kind of ownership or control of the establishment being a felony in Massachusetts and not here. So seeing that influx. He also did speak to the challenge of that knowingly piece. We had a look, and the other standards don't seem like they fit any better there for that. I'm not sure.
Yeah, and that's a matter.
That's a
Just to follow up on that, and one more piece. You know, that's a matter of the word we put in there. I mean, we can say that a landlord is an accomplice if they act recklessly, that you know, they don't.
Right.
yeah.
Yeah, yeah, there's language. I had another brilliant point, but I forgot it.
Yeah.
We would definitely be amenable if there was a different word than knowingly, like what Representative Scher is saying. So we're flexible with that piece of it.
I had a question for the town of Derry. I'm just trying to brainstorm ways that, did you hear what I had mentioned about a local, some type of local license or registration for a massage therapist? If we were to empower a municipality to enable that, something where your health department could go in and check licenses, whereas OPLC doesn't have the staffing or the time or expertise.
Thank you, Representative. We do have a full-time health officer in Derry, so that would help Derry itself. I just don't know how many communities have full-time health officers.
Yeah, no, it would be an option, not a mandate. So it would be a tool, maybe that would help. Yeah, yes.
Remember my other brilliant point. It would be helpful, regardless of what else happens, that the task force consider having a legislator on there, because it really it improves the flow from what the task force is doing, ideas that come up, to what we are trying to do here.
Yeah, so if you want to drop that in somebody's ear, that might be.
That's the
Oh,
somebody.
it's in your ear.
You did it. Yeah.
Very good, thank you. All right, anyone else want to address us on this? I think what I'm going to do is I'm going to start a craft. I'm going to craft a sheet, and we'll start circulating and see what we can get for ideas. And I'll set a date. We'll come back in a couple weeks, and let you know where we're at, and be prepared to submit to the full committee a piece of legislation.
Yeah, we
And-
just really appreciate your dedication to this because it really needs to be addressed. And we
Yeah.
were really hoping that we wouldn't spend another year studying without
No,
taking
yeah.
at least some action. So we're just really grateful for all of your consideration.
I dislike study committees because they just don't have the time to do anything. When you look at it logistically, they don't finish and get ready to start their work until September, and they only have till November. And I just don't feel like that lends itself to a good work product. And I don't think the speaker likes them either. So we're gonna come up with some actual legislation. If anyone wants to reach out to me in the meantime, if they have another brilliant idea or thought, you know how to get in touch with me. So just keep your eyes peeled for when the next meeting is if you want to come, and we'll hopefully have a piece of legislation. Thank you. And with that, I close that one. And the next one I'm reopening is, yeah, I racist it. What is it?
257.
I'm reopening House Bill 257 subcommittee work session. Okay. Oh, I know. Yeah. Okay, so when we last left off, Representative Scher had proposed a change to RSA 639-3, and we were interested in actually running this by the county attorneys. I think that that's a capital idea. And if they think that that would accomplish it, that would be much simpler and cleaner. So, yeah, I was hoping they were going to be here. Are we early? No.
Early. Yeah. He's supposed to start at 11.
What time is it?
10:33, 10:25.
I'm on a different time zone.
I know.
All right, so the hearing that I opened an hour early, I'm going to recess again, and we will come back at 11. reopening the subcommittee work session on House Bill 257. And I believe we wanted to hear from the county attorneys. It's my understanding there's a bill very similar in the Senate right now. And I was wondering what your thoughts were regarding that.
I've looked at that previously. I don't have it in front of me, so I don't have the direct language, so it's hard to make an intelligent conversation. But based on just speaking with the Office of the Child Guardian, I think part of the problem is there's not a mental state in there. And I think even that and Representative Shear's proposed amendment to changing the endangering the welfare, would default to a knowing mental state. And a lot of the conduct we're looking to address here is not a knowing mental state. It's not someone who has an idea that their actions are going to cause this result. And so I think we're still going to end up in the same position where a lot of this conduct just falls through the cracks. And yes, changing it in 169C may mean that DCYF has different avenues to go down, but it does not provide
A law enforcement.
no, it does not provide a law enforcement angle. And so it sort of leaves us in a spot where we can't do anything and leaves us exactly where we are.
And to demonstrate the examples, the mental states for criminal are purposely, knowingly, recklessly, and negligently. Knowingly would be a lot harder to prove, obviously. And if you have a situation where a parent has left drugs out and a child ingests said drugs and is seriously injured, that might be not a knowing mental state. They might not have known that certain conduct would result as a result of their act.
So what would that be?
Negligent.
Negligence? Gross negligence?
Exactly. It would be negligence. Same with if you had a significant other that you were aware of has a past behavior of sexually abusing children. You left them with your own children unattended. You might not know that that conduct is going to result, but if it does result, it's because you took a substantial and unjustifiable risk that your child would be sexually assaulted. And if in fact they were sexually assaulted, that would be negligent and not knowingly.
Okay. I had another question. With regard to our statutes around manslaughter, I know a lot of states have a depraved indifference standard for manslaughter. In other words, you leave out drugs you should have known, that shows depraved indifference. Do we have something like that? How would you charge on a case like that?
So that would be a negligent homicide. So there's a manslaughter, but there's also negligent homicide too. I think that would more appropriately fit the negligent homicide standard. And it's a substantial and unjustifiable risk. But like we talked about last week, if you had a child that ingested drugs that did not die,
Yeah.
there would be no avenue to charge that individual.
So they could have permanent brain damage.
Correct.
And that person's not going to get charged.
Correct. We could kind of try to twist it to fit into a reckless conduct with a deadly weapon statute, but whether or not drugs constitute a deadly weapon, juries have trouble wrapping their brains around titles of the
They
statute
can see
from
when
which
you're
they don't
walking
see.
on a tightrope.
Yeah.
Yeah.
And
Exactly.
that is something that's happening. There's a case for review in my office where just that happened. A child ingested drugs. Ultimately, that child was able to be revived and is largely okay, but it does not fit really anywhere else unless we sort of strong arm it into a reckless conduct deadly weapon.
And I don't see that scenario fitting in the knowing standard for the amendment of endangering the welfare of a child that Representative Scher put forward, or the amended, I think it's SB 23.
Yes, it's right in front of you now.
Oh, that's helpful. And that wouldn't pertain to that fact pattern as well.
And this is a knowing mental state. It gets rid of the word purposely, so it is still a knowing mental state. So it's very similar in that regard to Representative Shear's amendment to the.
And the state that
endangering
you're
welfare.
looking for, to be clear, is
The bill we proposed is a negligent. mental state.
negligent. Okay. Would that apply? We talk a lot about drugs. There's a lot of other scenarios like leaving a firearm around. Would this be the same type of thing, or having a dangerous animal that attack? We've had several cases of children being attacked by dangerous animals that people possess. Same type of scenario?
Yes, I think so. There's actually on the books a negligent storage of firearms that pertains to leaving a loaded firearm within a child's reach unlocked. If a child, I could see a fact pattern in which you could fit that into like a child being around a firearm, doesn't know how to use a firearm, it's loaded, is gravely injured, or injures a friend. I think that would fit this particular fact pattern.
Okay, I'm just trying to think of different scenarios that would be caught into this. Okay. Was there anything else you wanted to tell us?
I think we would just like to emphasize that though there is a civil avenue that's being sought by the Office of the Child Advocate and DCYF to amend that statute, that doesn't mean there doesn't need to be a criminal statute as well. There's a lot of issues with how the timeframes for DCYF can prolong these situations where children are placed in danger, where having an avenue to charge somebody criminally gives us a lot of options as well for helping. And I think what we emphasized last week is this would be a deterrent and a big deterrent
Yeah.
for people to take.
And I
proper
think
care
you
of their
also
children.
testified last week that it's not only about the stick, it's also a little bit of carrot as well, as you can get them into the system and offer them.
Exactly. So, for example, in Stratford County, if we charge somebody with a crime and they are placed on bail, we have a host of services that we can provide that individual on bail to not only make sure that they comply with their bail recommendations and not commit any other crimes, but help them get mental health treatment, substance abuse treatment, all things that could help them with their DCYF plan to reunify, but also have a check on them to make sure they're doing it and have a supervisor assigned to make sure they're doing it, who will inform the court immediately if they're not doing it, which can help us, again, protect the children that are hopefully not left in their care, but it's sometimes left in their care.
Okay, thank you.
I would also just note, to the extent that there are different definitions in 169C versus the bill that's been put forward, from our perspective, that doesn't raise an issue. Prosecutors would be looking at the criminal definition, and I would note that the definitions throughout the criminal code are inconsistent. If you look at child under the sexual assault statute, a child is defined as somebody under the age of 16. If you look at child under the child sexual abuse material, child is defined as under 18. So there are inconsistent definitions for these words within the criminal code that we already, every single time you go to charge something, need to go back to the definitions and make sure you are within the proper framework. So to the extent that it's a different chapter of the statutes does not align perfectly with the criminal code, I don't think that that's a significant concern.
Well, I would suggest to you that if you happen to have yourself a summer intern and you put them to work and give me a list of all those definitions you need to have fixed, I'd be happy to submit a bill to do that.
Thank you.
Yeah, are there any questions from members that would like to ask to elucidate some information that we don't already know? Seeing none, thank you very much. Anyone else want to address the committee? Officer, were you here or did you want to talk? Chief? Based on the stars, I'm going with Chief.
Good morning, Chairman Roy and the members of the committee. My name is Alex Lee. I'm the Chief of Police in Newport. Detective Marvin wanted to be here this morning, but late last night he was involved in the arrest of a child protection, child predator situation. So I told him he needed to stay home and get his work done. But I've been a police officer in New Hampshire for 21 years. I was a detective for the state police before going into local law enforcement and becoming a chief. And my whole career, I've specialized in child protection cases. So I just wanted to reiterate my department and law enforcement's support for this bill. I'm more than happy to work with members of the subcommittee or the full committee on the nitty-gritty details of the bill and any amendments that should be made to particular sections of the bill. And I'm a member of the Attorney General's Sexual Assault Advisory Board, and we discuss bills like this as well as part of that board. So I'm more than happy to work with the committee on any questions you may have about different scenarios like you were presenting to the attorney and give a law enforcement perspective on that. But I do think that it is critical that whatever bill is passed, that it has a culpable mental state that is provable in these types of cases. Because if the culpable mental state is too high, then I think the bill loses its purpose entirely because we just cannot use it. So I would certainly support a negligent mental state for these types of cases. And with that, I'm happy to take any questions.
Thank you. You mentioned you were on the Attorney General's task force and they looked at, did they have a chance to take a look at this proposed legislation?
We have a meeting scheduled at 1 o'clock this afternoon, so I'll be giving the board an update.
I'd be pleased to hear what the feedback is that you get. If you want to send it to my email, that would be good, so I can circulate it with the rest of the committee members.
I would be happy to do that, sir.
Thank you, Chief. Any questions for the Chief? Yes, go ahead.
Thank you for taking my question. Did you see the, or read the SB 23, the Senate bill regarding this as well? Just curious.
I haven't had a chance to review all the details of that bill. I am aware of that bill. I think this bill in front of you has a framework that is very useful from a law enforcement perspective. Every child protection case is very different, and they call for very different responses from our multidisciplinary team. So some child protection cases are really most suitable for a civil child protection response. Other cases that are more egregious are really more suitable for a law enforcement response. But what the public really expects of us as a whole, as a system, is that we work together and we address each situation with the proper tools. And I think we are missing a very important tool in terms of the law enforcement response to these cases that needs to be available to us. And I think this bill provides that.
Thank you,
Thank
Chief.
you.
See nothing else. Thank you again.
Thank you.
Anyone else wishing to address us? Please come forward.
Good morning. I don't get to visit the Criminal Justice Committee very often anymore. My name is Attorney Lissa Massio. I am the Associate Child Advocate with the Office of the Child Advocate. I used to show up here when I worked for the Department of Corrections several years ago, but in our current role, we do not specialize in criminal law, so we tend to be in children and family. We did sign in last week on this bill. Unfortunately, I wasn't able to attend the hearing, and I wasn't able to connect with the county attorneys. We do have concerns about this bill as written. The stakeholders were not involved from the outset, so we did sort of catch wind of this a little bit late, did not really get brought into the conversation. As I said when I signed in, we just have concerns as it's written. Neglect really is a term of art used in 169C. It is defined there. I think a lot of the questions last week that I heard, I did watch on YouTube, were very insightful about sort of the breadth and vagueness of this language. And I did come today to be able to point out to the committee that SB 23 was filed. We've actually been working with Lieutenant Nicholas Georgoulis and the chiefs of police for quite some time. That language has actually been floating around for a couple of years with a number of stakeholders on that language, because absolutely the cases that were talked about last week were horrific and should not happen. There are definite gaps in the system. That is why the Office of Child Advocate was created, was because of cases like those. I heard Mr. John DeJoy's testimony last week, and we agree with some of his points. It is the child protection system that failed and had those gaps. We are working on a bill there too. HB 553 was actually just heard yesterday. There are additional definitions being proposed, including very specifically under the definition of neglect, this idea of entrustment to an inappropriate person. In addition, SB 23, by enhancing endangering the welfare of a child, which I know you mentioned, we think between those two bills, really these gaps can be filled, and we are hesitant with the way this bill is currently written to add an additional crime. It may muddy the waters. It certainly is more difficult to reunify a family or provide services when one parent is incarcerated or taken out of the home. We don't really support the idea of a criminal law being used to threaten people and force them to follow a DCYF safety plan, because as someone asked last week, the result of not following a DCYF safety plan is having a DCYF case filed. And the end result of that, if you do not comply, is that you have your parental rights terminated. So that is an extreme outcome. We don't know that adding an additional criminal law will help that system work any better. We obviously support the protection of children and want cases like we heard about last week not to happen. That is the purpose of our office. We're happy to work with folks. We wish that we had kind of been involved with the drafting of 257 earlier on. We hate to come out against things that are intended to help children, because this bill, the intent truly is important. There are gaps in the system. We want to see them closed. We think that maybe working within SB 23, and we hope that HB 553 has some of those pieces too to fill those gaps in cases like that.
Thank you. It seems to me, though, our statutes have a couple purposes. One purpose is the deterrence that we talked about, and another is punishment. And so some of the things we heard last week warrant punishment.
Absolutely.
So the two bills you've talked about, and really your office's bailiwick isn't necessarily in the criminal prosecution, that punishment aspect to the people that do these things, is it?
SB 23 is a criminal law, yes. That one, it makes amendments to the child endangerment statute
Yeah.
to enhance that area. And I think if this committee finds gaps that may be able to address within that child endangerment, maybe flesh that out a little bit more rather than adding this new crime that is kind of broad and kind of vague, may be more helpful. The reason that we were involved with SB 23 is because of that multidisciplinary team that the chief mentioned.
Yeah.
Often a case, particularly for abuse, will involve both child protection and criminal prosecution, and it is typically child endangerment. And I did hear testimony last week that law has some gaps too. It's hard to prosecute. The penalties were minimal, so they weren't really using it. So SB 23 is to enhance criminal law and specifically the penalties as well, to make them felony level in some cases, which would make them more prosecutable, that it's a higher level penalty, because exactly those charges that didn't happen in those cases last week deserve to
Yeah.
be felonies.
Yeah.
And that hadn't really existed. So SB 23 is criminal, which is why it was not a bill the OCA was putting forth. We worked on it with Lieutenant Georgioulis because he frequently works with us on those multidisciplinary teams. He's a juvenile detective. So yes, criminal law is not our bailiwick. We let him work on that with the chiefs of police.
Okay, thank you. Representative Murray, you have a question?
Well, I was thinking along the same lines with the punishment versus the deterrence of this, but with SB 23, do you have thoughts on, it looks like there's already an adjustment to change from purposefully endangering the welfare to knowingly. Do you have any thoughts on like lowering that even more, like to negligence?
I would defer to the law enforcement folks. I practiced in the DCYF land, in the civil land. I dabbled in homicide prosecution at the AG's office for a moment. But definitely I know Beth Sargent from the Police Chiefs Association is here. I heard Chief Lee, sorry, say that he was willing to work together. So I would absolutely defer to them of what the mens rea needs to be. Obviously, civil, it's preponderance of the evidence, it's a much lower standard, but I would put out there that if they're having trouble charging and reaching that criminal standard, that is a reason why we are also trying to bulk up that civil standard, because preponderance of the evidence is much lower to really fill the gaps from both ends. But I would defer to them as to what they felt the mens rea needs to be from the cases they've seen.
Thank you for sharing with us today.
I do know the words mens rea, but that's
That's enough.
thank you.
I heard that once on Law and Order myself. Anyone else wishing to speak to us who has not yet done so? Seeing none, thank you very much. And we're going to close the subcommittee work session on this bill. Like the last bill, I think what we'll do is we'll start off with a draft piece of legislation and see what we can come together. And in a couple weeks, we'll have a better feeling on what the outcome of the Senate bill will be, and if that bill in any way addresses the concern that the county attorneys had. And if it doesn't, we'll move forward with our own bill. Thank you. That I'm opening the public hearing on House Bill 500, establishing an enhanced enforcement zones for motor vehicle speed enforcement, increasing penalties for speeding in those zones by 50%, et cetera. I invite the prime sponsor to introduce the bill. Is it me? Please tell me it's not me. Okay. I know I'm one of these.
Good morning, Mr. Chairman. Good morning. Well, I guess it's not anymore, but good noontime to the Criminal Justice Committee. For the record, I'm Representative Steve Pearson, Rockingham District 13, which encompasses the town of Derry. What I bring before you today is House Bill 500, establishing an enhanced enforcement zone for motor vehicle speed enforcement and increasing penalties within those zones. I'll give you a little bit of my background. I've been a firefighter in New Hampshire for 24 years, serving the overwhelming majority of that in the city of Manchester. I have spent time on actually all three engine companies that I worked for in my career in Manchester, had responsibilities on the interstates. So what I'm bringing before you here is something that is potentially a way to address a problem. We have a significant speed problem on our divided highways. Just recently, Interstate 95 experienced, over the course of several Wednesdays, we're really not sure why they were Wednesdays, but some horrific accidents, fatalities. We've had a very interesting and alarming number of fatalities in the recent months. And there's got to be some sort of a mechanism here to curb this. Now, law, generally speaking, does one of three things. It either tells you to do something, it tells you not to do something, or it tells you how to do something. But law has to be effective. And through the, I suppose, wonderful work of the Department of Transportation and the automobile industry, we have the ability now to travel at speeds quite comfortably that we, in the past, really never entertained. Just driving up here today in not very good weather conditions and setting my cruise control, 17 people passed me above 75, 4 well above 80. That's just one ride up here. And anybody that comes up here to the State House via Interstate 93, I'm sure is well versed in what they've experienced with their own two eyes. So I took the thought process here and said, okay, we need to increase enforcement, especially in these areas. So how do we do this? And how do we do this in a way where we're not whacking the taxpayer necessarily with the responsibility of an increased enforcement presence? Now, my understanding is, based on current law, speeding tickets are used, the money generated from speeding tickets are used to fund the court system. What I am proposing is not eliminating that in any way. The courts will still get their revenue, if you will, their funding from the generation of tickets, but within the enforcement zones of these areas where we see the daily 100-mile-an-hour vehicles, the enhancement of the fine will go towards a non-lapsing fund to be used by the state police to pay for enhanced enforcement. Because, of course, if you put additional law enforcement on the road, that is going to come with a cost. Now, we have to be realistic here, right? Everybody's had that moment traveling down the road where they look down at the speedometer and go, whoa, hey, I didn't realize I was going that fast. So there's got to be a logical threshold as to where you go from, hey, I'm just kind of cruising around and not really thinking about it, to, you really have to be thinking and be well aware of that you are traveling in excess of posted speed limits. So 15 miles an hour seemed like a good starting spot for that. That way, we're not sitting here pulling people over for 5 over and 6 over and, something that's really just, hey, I was going down a hill, or, I'm just cruising along with the guy that's in front of me. So that's the precipice of this entire concept. It creates a non-lapsing fund, which then pays for the overtime or whatever we need the fuel, whatever the cost is associated with having enhanced enforcement. And if you simply don't want to fund it, don't speed. It's just that simple. I'd love to see the fund have nothing in it, because that would mean we would have compliance to our roads here. I don't really want to get into the breakdown of the license plates for the people that fly by me at excessive speed. They happen to be mostly red. That's not a reflection on our current state legislative plate color. But it is not certainly solely the folks from other states that are doing this. We bear responsibility as well. So this is kind of a new concept. I'm not aware of this ever being proposed or enacted before, but it is, a new idea to try to get better compliance on our divided highways.
Thank you, Representative, for bringing this bill to us. Have you had any contact or input from the Department of Safety?
Absolutely not.
Okay. I'm actually, I have a bill that we'll be hearing that I actually filed with regards to speeding over 100 miles per hour. And the Department of Safety actually requested that we file it because you are correct. The accidents and the severity of them have increased exponentially over the last few years. So they're aware of it, and they also find it to be worthy of legislation. So I will definitely, when we bring up the bill that I'm proposing and your bill, we'll look at the two of those together. Absolutely.
Sure.
Questions for the representative? Yes, Representative LaSalle.
Thank you for taking my question. When I was growing up in the 50s and 60s, if there was an automobile with more than 300 horsepower, that was a high performance automobile. Today, you can buy from a dealer cars with 600, 800 or more horsepower. I don't know where it stops, but when you see these cars that are going over 100,000 or 100 miles an hour, you wonder, maybe they're just cruising along with their 800 horsepower, whatever, I saw the other day on the news, there was somebody who was in a 35 mile an hour zone going over 100 mile an hour.
I would very much, Chairman Roy, believe that. Yes.
It's horrendous. Now, this bill would not do anything to that person. Am I correct?
Yeah, I don't believe we have any 35-mile zones on our divided highways. So no. That would be a local issue.
Did you consider a different, looking at the whole, the way that we structure our speeding fines? I know the way they do it in the state below us that shall not be named, that I believe for the first 10 miles an hour over, it's $50. And then I believe it's $10 for every mile an hour thereafter. So it gets up into the $400, $500, $600 range when you start going up that many miles an hour. Did you look at how our speeding fines are structured?
No, what I don't want to do is I don't want to, at least in my mind, I don't want to have the guy that's looks down and he's doing 8 over. I mean, that
would be $50.
Yeah. I mean, we have an intent, right? I mean, I'd like to believe folks generally want to do the right thing. Right. And again, we're growing up in the 80s. Okay. The pothole era of New Hampshire. you know, in vehicles of that time. And I can certainly address and speak to, I'm a hot rod guy. I have 9 antiques, but, so, you know, there is a marketable difference between my 2017 Buick GS, which is the same horsepower as a 1986 Grand National, right? And the Grand National was considered a race car. So yes, you know, things have progressed, things have changed. The Dodge Hellcat is 800 and show roughly 800 horsepower. So but again, I don't want to get into the like you see in like small towns in Missouri where they're writing your speeding ticket for 4 over. I just don't think that's the intent and the idea behind this. This is for the folks, when you get above 15 over, you know you're speeding. You know you're exceeding what is reasonable. And that's really where the enhanced enforcement zone comes to fruition.
Representative Scher.
It would be helpful if you could talk to the Department of Safety and see what they think about this. I'm uncomfortable. I mean, I like the idea, in spite of the fact it might affect my commute from Portsmouth. But it would be useful to see what they think if they're on board with this kind of new structure.
Well, you know, the purpose of a public hearing is to bring forward opinions and ideas of those affected by legislation, and that might happen. So I would also like to point out, and I don't know how this happened, shame on me in the proofreading process, Interstate 89 was supposed to be included in this, and for some reason it is not. So I'm not here to let the folks on our western area of the state off the hook in this concept. But that was an inadvertent omission.
Okay. If we work on the language, we'll reintroduce that. Any further questions for the Representative Peru?
Yeah, I'm thinking like 20 or 25 miles an hour over, because like you say, in these cars, if you're not paying attention, it's really easy to get up to 25 over and then look down and say, oh crap. So that's where I'm at.
At 25
Would you
over,
believe that's where I'm at?
well, you know, Representative Peru, knowing that your background is similar in a lot of ways to mine, I would believe that, but let's look at some of the math here, right? So you get north of Concord, the speed limit goes to 70, right? In theory, if you look at the Federal Department of Transportation's guidelines, interstates are designed at 75 miles an hour, right? At that rate, you'd be doing 95 before you hit that. 95, you know you're doing speeds at that excess. So
At the 60 follow-up. At the 65 mile an hour speed limit, 20 over, it's probably 85, but I'm thinking 80.
Okay, we can have that conversation in executive session. I just want to go on the record, and this is all the fault of the electric car people. They're the ones who came out with that ridiculous car that has ludicrous mode, and it goes 170 miles per hour. That would be the what is it? The Model S.
well, Chairman Roy, I believe ludicrous speed was established in Spaceballs.
It was.
So,
but they did steal that.
So the other thing too, to touch on that, you know, when you talk about today in the automobiles and the capabilities that we have today, I'm trying to think of the non-slang term to describe Japanese manufactured motorcycles. Okay, Kawasaki's, Yamaha's, those type of bikes. There's nothing closer in commercial purchasing from a full-on race vehicle to a Joe Schmo purchasing vehicle than those type of motorcycles. Like very little difference. So, you know, we've had, I've lost a colleague actually on 93 on one of those back 25 years ago. So, you know, we've experienced the capabilities since the Ninja came out that we have that problem. But motorcyclists have a tendency to, in some ways, when you start to get to speeds like that, they kind of are steering their own destiny. This is now translated over into pickup trucks and Buicks and sedans and Camrys and things that really back in the 80s were running at about 85 horsepower. and would do 65, but you didn't really like it if you got above 75. So, you know, it's a matter of changing with the times, I suppose, a little bit here in the advancements in technology of both road construction and automobile manufacturing.
Thank you. Anything further? Representative Muse.
As you went about thinking about penalties for the bill, one of the things that I'm interested in is, did you find any evidence along the way that changing or increasing the fine would have a dramatic impact on behavior? And I'm thinking especially of that person who buys the 800 horsepower car probably can afford, whatever the increase in the fine is. So are we really changing behavior with the fine?
Well, I mean, like I said, the intent here is to provide a mechanism to increase enforcement. Okay. The state police have a lot of struggles right now in staffing levels, and, they're stretched extraordinarily thin. Using a mechanism of a non-lapsing fund to provide more opportunities for them is just part of an overwhelming goal of the administration to bring law enforcement back up to full strength. It's multifaceted, but this is just another, I don't think anybody's going to join the state police so that they can work overtime in a speed enforcement zone, but I think it's just something else that adds to the plate of opportunities that they have. As we're in budget season and we look at the financial implications of everything that we do here, this particular mechanism is self-funded. It's not a budgetary impact thing. And again, if we're not pulling people over and we're not issuing tickets for folks that are exceeding these numbers, then the fund has no money. But we're well aware that that's not going to be how things go.
Representative Newell.
Thank you, Mr. Chair, and thanks for taking my question. I am wondering about letting people know. So, increasing awareness around it in the first place so that, I would hope that people wouldn't find out when they get pulled over, but rather be deterred from speeding, right? So,
Well, as far as I know, on the border of 93, we don't have any signs that say we don't really enforce speed limits. I mean, we're not trying to advertise that, hey, just kind of rock on here. We go to 5 lanes in Salem, let's go, So, I mean, for us to advertise, hey, we actually enforce our speed limits, I'm not really sure how,
well, I think when you talk about an enhanced enforcement zone, some of those would be if there's construction going on or for one reason or another, if there's a reason for people to need to slow down. So we do, there's signs that warn people of that.
Sure.
I'm just wondering if.
Well, I mean, if they want to put, if the Department of Transportation under our wonderful French welcome sign wants to put, enhanced speed enforcement area signs, I mean, that's up to the purview of the Department of Transportation if they want to advertise that or not. I don't know that saying, hey, please comply with our law signs are necessary, I suppose.
Well, I believe they already do it with airplanes. They say are in force and radar in force. So, I mean, some more vinyl
Sure.
stickers on a piece of metal. I don't think that we would get involved in legislating that, though. I think that they would determine that. And frankly, I think the advertisement would be in the media if we were to enact such a law.
Sure, the Department of Transportation and the state police, they all have websites. They all have avenues to disseminate information. I mean,
Okay. Thank you. Thank you.
thank you.
Chair calls Captain Amatucci.
Thank you, Mr. Chair. And thank you to the members of the committee. My name is Matt Amatucci. I am here representing the New Hampshire State Police. We are neutral on this bill, and I just want to go over some statistics and some other information that I have. So first off, the state police is appreciative of the fact that speed violators are viewed as an issue throughout the state. we recognize that there has been an increase in speed violators throughout the state over the past several years. From 2022 to 2024, there has been a 39% increase in summonses issued for speed-related offenses 15 plus miles an hour over the posted speed limit in 65 plus mile an hour zones. And during that same time frame, 39% increase in summonses issued in, 36% increase in summonses issued for 15 miles an hour over in 55 and less mile an hour zones. So we are seeing a drastic increase in violators, but we're trying to address it as best we can with citations issued. Even with the increased number of citations being issued by state police over the past 3 years, there's been little change to driving behavior. If the intent of this bill is to act as a deterrent by increasing fines, it could be accomplished by increasing the uniform fine schedule for 55, 60, 65, 70 mile an hour zones by 50%.
Did you, and I don't want to interrupt, but since you brought it up, did you hear the question I asked with regard to the structure of how we structure our speeding fines versus how Mass does it?
I did.
What are your thoughts on that? Do you think our structure, the way it's set up, is the best, or do you think we should look at changing that?
I think it could be revisited. We haven't, I don't believe, adjusted our fines in number of years, and a lot's changed over the last 5. And the uniform fine schedule hasn't been adjusted since prior to 2019 anyways. Those funds could still be allocated as the committee deems appropriate. I think a more effective change to driving behavior, it may be beneficial to look at crash data and speed data on our highways and strategically post enhanced enforcement zones, as you had previously stated. Those warning signs could read something to the effect of high crash area ahead, speeding strictly enforced, fines increased by 50%. I do think that education warnings will help deter. Fines also are used as a deterrent, but I think in this case, specifically on our highways, looking at data as it relates to crashes and speed, and posting those areas like you do with construction zones may be effective. And this bill was not proposed by the state police. We're neutral on where the enhanced speed zone fund is appropriated, whether it's the Department of Safety, the general fund, or otherwise. I appreciate the innovative thinking as to how some of these funds could be utilized to support the initiative of speeding violators. So with that, I'll be glad to try to answer any questions.
Thank you, Captain. Could you explain to the committee how it works with regard to warnings? Specifically, if you were operating in one of these zones and the law just came into effect, I assume that there would be some type of directive for a little bit of a period of warning people. When you give someone a warning and then that person's pulled over 2 weeks later by another trooper, what do they see?
You could see their motor vehicle history. In our in-house system.
Yeah.
Local agencies, many of them use a different system. They can see local history to local history. We're on a different system than many agencies. So we can't always see if they were warned in a local town or city necessarily.
But what does the warning say? Does it say warning for speeding?
Correct.
So you'll know what they were warned for.
You know what they're warned for in the zone or whatever the infraction was, but not necessarily how fast they were going.
One other question I had is regarding insurance. In New Hampshire, we don't require all drivers to have insurance. One of the big deterrents in my mind is you get a speeding ticket, your insurance goes up significantly. If you're not required to have insurance, that doesn't really impact you. At what point are you required to get insurance in New Hampshire? Is it only after an accident where you're at fault, or can it also be for violations?
I know for accidents, you're required to have insurance. I'm not sure if you hit X amount of points if you're required to. I'm not aware of that.
Okay, thank you. I think that's something to look at because I know for me, the ticket would be painful, but what would be devastating is the insurance increase over the next 5 years, which is exponential. So if someone doesn't have insurance, doesn't matter to them. They pay the ticket and they move on. So thank you. Any other questions for Captain? Yes, Representative Newman.
Yeah, I have a question on one of the things that the chair said about speed check by aircraft. Do you have any data or anecdotal information on whether that's a deterrent or you find that out as a deterrent? It seems to me that when I think some of the aircraft's up there, and I don't know whether he's there or not, and it may be because I used to do air traffic stuff, that I would say, this is, if I were intending to go faster, I would slow down.
Yes, sir.
What do you think about that?
Yes, sir. Thank you for the question. Yes, our aircraft is extremely effective. Those signs that you see are typically warning operators once they've traveled through what we're looking at to warn you that there are going to be officers on the side of the road. That's not warning you that to slow down at that point. It's warning you that there's going to be several troopers ahead of you that have already stopped vehicles, but you've already traveled through that zone. You know, there's 4 zones that we're looking at. So yes, we're warning there is a deterrent. We're trying to slow operators down and have them move over because we're going to be stopped on the side of the road with other operators at that point.
I just think that it may be a deterrent when you're not even around, that's anyway, but I'll go on to my question. You mentioned that an accident causes an increase in insurance. I'm just curious how that works. I know that trying to get a law to pass insurance, the insurance companies don't like that because they don't want it to be mandatory, especially a minimum, because they don't make any money. Do you have any, just explain to me what happens after an accident?
So from my understanding is once you're involved in an accident in this state, you're then required to have insurance. Whether it increases, that's up to the insurance company. We do get complaints often from those south of us because of just that. Their insurance is going to go up for 5 years, hundreds of dollars per year. They're not concerned with a $500 ticket. They're concerned with the fact that it's going to cost them $3,000 over the next 5 years because of the increase. To answer your previous question, there are states that have affixed signs along the highway saying that the highway is monitored by aircraft, and those stay up year round whether there's aircraft or not. We just have the temporary ones while we're out enforcing these that and that's more to warn operators that ahead of you you're going to have multiple cruisers, and we do see vehicles slow down at that point, move over, because we don't want to have accidents or get struck by passing motorists.
We might need the permanent signs. Thank you very much.
Yes, sir.
Representative Newell.
Thank you, Mr. Chair, and thanks for taking my question. I, as you know, the mom of 2 kids who are, one just got his license and the other one is coming up, keenly aware that we have a serious issue with youth accidents and even deaths and things like that. And so hearing a whole lot about that. Generally speaking, what I've heard is that it is mostly distracted driving, or I'm just curious if you have any data or anything like that to say that speed might be a part of that, or have you seen that speed is a part of the youth? I'm sorry, I'm trying to say it. Part of the reason why we're having so many accidents with the youth. I'm sorry. You get what I'm saying,
Yes.
right?
Thank you for the question. Yes, as it relates to our fatalities, distracted driving, impaired driving, speed. Those are the 3 things that we see in nearly every fatality. There are instances where it's medical related. Somebody has a seizure while they're driving, but the vast majority that we are seeing, it's impairment, it's distracted driving, and speed related.
Okay. Thank you.
And that's across the board, whether it's youth or anybody.
Representative LaSalle.
Thank you for taking my question. I'm a great believer in technology. And I'm just wondering, do you folks, like for instance, where the hooks at tolls are, all right? There are cameras there and there's ways of keeping track of cars. If we had another set of just sensors, north of that, maybe 10 miles, and if we could keep track of how much time it took a vehicle to get between that 10-mile stretch, and if they exceeded a certain amount, could we summarily pull these folks over? Is there a way that you're looking at technology to act as a deterrent?
Great question. Not that I'm aware of. I mean, there's a lot of technology that's out there. You see the red light cameras in other states. You see, speed. Obviously, when you go through tolls, it does track speeds. It's a great question. I don't have an answer on that particular question as far as what technology is being used. We do test license plate readers, but those are more for like stolen vehicles and things like that. There's a lot of technology out there and it continues to grow. How can we effectively utilize that the citizens of the state are comfortable with? I'm not sure.
Thank you.
I can tell you that stoplight cameras are not one of them. Representative Murray.
Thank you, Mr. Chair. Just to follow up on that, so to clarify, do we ever issue like mailed tickets to people based on like enforcement radar or whatever that we may have picked up, or is it really just all about like the in-person on the side of the road enforcement? Is that like the only avenue?
Yeah, it's in person. There are times where you get mailed a ticket for one reason or another. My printer's not working. I can certify mail you a ticket, but I have to identify who you are. It's unlike Easy Pass, where if you violate it, the operator of that vehicle is going to receive a citation or fees in the mail. We don't do that as far as speed is related.
What about after accidents? Sometimes do you mail citations after an accident investigation is complete? Maybe not.
That I'm not sure. I mean, there's times where we certainly charge them with different things. I don't know if we would just mail them a ticket. It would probably be a must appear. They'd be issued a court date, and then a complaint would come with that. I'm not sure that they would just be sent a citation in the mail upon the completion of a investigation.
My last question with regard to speeding and arrest. We see a lot of times in the media where someone, it's usually those motorcyclists, are going a certain amount over the speed limit and they end up being arrested for it. What is the charge they use to arrest a speeding motorist?
Yes, sir. Reckless operation. So when the law was changed that allowed for if you're traveling 100 miles an hour or more, it becomes a reckless operation. That is a arrestable offense.
And does the state police have a policy as far as shall arrest, or is it really still up to the officer discretion?
Still up to discretion.
Good. Okay, thank you. Representative. Yeah.
When people go through the tolls, you have a plate, and can you capture the speed? And if you capture a speed that's
No, you need a radar.
outrageous, can they? Is there a law? Can they send a violation of some nature? Just curious.
Thank you for the question. That's all tracked by Easy Pass, and it's a separate entity from us. They don't share any of the information with us, and any time that we try to obtain it, we have to do a search warrant to get those records.
Thank you.
Representative Scher.
Three types of deterrents that I see in this circumstance. I'm not a big fan of fines as a deterrent. It's just a flat out punishment. I think most people don't. But with fines, increase in insurance, loss of license, those three are the classic deterrents. Could you give me your judgment as to the effectiveness of those as a deterrent?
Yeah, they would all be viewed as deterrent based on the person. You know, if people have the funds, then the monetary loss that they face may not be as impactful. You know, the loss of license, that may be more impactful because they're trying to get to work. They work for a high paying job, hypothetically, if they're so I think deterrents are important. I think education is important. I agree that the vast majority of the people on our roadways are law-abiding citizens that want to do the right thing. Have things been, you know, have we seen an increase in speed over the years? Yes. And that's why bills like this are good to take a look at, work with, in an attempt to help combat and get all operators on our roads feeling safe in a more safe environment.
Thank you for taking our questions today. Thank you.
Thank you, sir.
Is there anyone else wishing to testify on House Bill 500 who has not done so? Seeing none, I hereby close the public hearing. We will reopen at 1 o'clock. What's the first one we have for exec? Yeah. Come back. Republican members, if you could just all stay here, we're going to reconvene in about 10 minutes to do our executive sessions we discussed. 94, 116, and 116, 116, 157. Thank you. Pending. Okay. Step with me.
Answer your question, in theory, if they tracked when you pass through the Bedford tolls and when you pass through the Hooksett tolls, it's a given distance, they could, you know,
afternoon. I'm opening the public hearing on House Bill 592, and I invite the sponsor to come forward. Am I doing that? Is it three? No, never mind. Sorry. Yeah, I thought it was later than it was. I want to go home, so I'm trying to move. Open the public hearing for House Bill 245, establishing the Speed Enforcement and Awareness Fund, providing grants for municipal law enforcement for speed enforcement and speed awareness. I invite the prime sponsor to introduce the bill. What do we got?
This is for the state.
Oh, you're the sponsor. Okay. Probably best you never know what you're seeing yet.
Good afternoon, Mr. Chair and members of the committee. For the record, my name is Keith Ammon. I represent Hillsborough District 42, which is Mount Vernon, Lineborough, and New Boston, where I live. So I'm introducing House Bill 245 to the committee. It would establish a speed enforcement and awareness fund and provide grants to municipal law enforcement for speed enforcement and speed awareness traffic equipment. So just a high level overview of the bill. This came about in New Boston, this idea, and the chair of our select board will be coming behind me and explain more, Mr. Bill McFadden. But the idea is we have a small town. We're kind of on the way to other places. And we have, tourists, people coming through our town, and we have to enforce the traffic laws. When a ticket is written, of course, it goes to the general fund and a couple other funds. And because, taxes are tight, we could use a little more speed enforcement equipment. So things like radar guns and signs and things like that. And so the idea is to direct a small portion of ticket fees to a fund that municipalities around the state can apply for a grant from. And that grant can only be used for a specific list of things that's mentioned in the bill. And that way it, would spread some of the costs around and make our streets safer across the state. That's the gist of my testimony. Happy to answer any questions.
Thank you for bringing us this bill, Representative. Some people, I'm sure, are going to argue that this may create a perverse incentive for police to write more tickets so that they can generate more money for more equipment. What would be your response to that?
Yeah, so certainly we wouldn't want to have the ticket written locally go to the local department because that would be a perverse incentive. So this doesn't raise or lower fees. The fees would still stay the same. Just a small portion would go to a pool at the state level. So it'd be a trickle from all the towns would go into this pool. And then the departments that might be short of equipment to enforce traffic in their location could apply for a grant. It would be a needs-based program, and the fund would be distributed to the towns that need it the most. So I think there's enough of a disconnect between the ticket itself and that fund being dispersed that it would not present a perverse incentive.
Yeah, it sounds like you have a few firewalls in there. You've got the first one where it's not going directly to the town. Then they have to apply for it. They're not even sure if they're going to get it. So that much distance would make it very difficult to target a specific piece of equipment and say, we're going to get this year.
Right,
So, yeah.
right.
Thank you. Questions? Representative Prue.
I see on your list you have automated speed cameras. Would you be willing to get rid of that? Because I think that's a slippery slope to go down.
Yeah, thank you for the question. So as is the custom, it's the committee's bill. So we're relying on your judgment on how to improve the bill. And I would certainly be open to that suggestion.
Thank you.
Thank you. Any further questions? Representative Scheer.
I'm just looking at the bill now. How is it determined how much goes to this non-lapsing fund?
It's on the last page of the bill. It's section 2, section 4, Roman numeral 4. And so what it's doing is taking the 66% that the treasurer would deposit into the general fund, and it's reducing that by an amount, and it's an arbitrary number, so that could be adjusted too. And that 8.3% would go to this new fund.
Got it. Thank you.
Seeing no further questions, thank you very much.
Okay, thank you.
The chair calls Captain Amatucci. Yeah.
Thank you, Mr. Chair and committee members. My name is Matt Amatucci with the New Hampshire State Police. We're neutral on this bill as well. This bill would align with the mission of the Office of Highway Safety in many ways. And I kind of just want to go over what the mission of the Office of Highway Safety is, more for educational purposes than anything else. So the Office of Highway Safety is responsible for developing, implementing effective strategies to reduce the state's traffic-related injuries and fatality rates. These strategies may take the form of standalone projects, activities, and/or comprehensive long-term programs. Both traditional and innovative strategies are encouraged and utilized to support the Office of Highway Safety goals. They do this as a pass-through entity for program funding received from the National Highway Traffic Safety Administration, also known as NHTSA, for things that include speed enforcement and equipment, amongst other things like impaired driving enforcement and equipment, distracted driving enforcement, occupant protection enforcement, pedestrian bicycle enforcement, as well as media and messaging and education outreach programs. So the Office of Highway Safety is responsible for administration of the federal highway safety funds and for facilitating the highway safety programs supported by these funds. Their funding is in the form of reimbursement to the sub-recipient under grant agreements and/or contacts. The only item in this bill that NHTSA doesn't fund would be the use of the automated speed cameras, except in school and work zone. That's the only place that NHTSA would allow for those funds to be utilized. I can say that the local agencies and the state police are not utilizing all of the funds that have been allocated, mostly due to staffing. I think that when New Hampshire law enforcement agencies are better staffed, it would be beneficial to have additional state funding available through innovative strategies such as this in this bill. So with that, if there's any questions.
Just if I could recap. So the NHTSA kind of does this already on a separate track. But when the departments get proper staffing and operating on all cylinders, there's definitely room for additional funding that this would, is that pretty much what you said?
Yes, sir.
Okay.
So essentially what's proposed is what NHTSA does on the federal level with federal grants that are distributed through the Office of Highway Safety to both state and local agencies at this time.
Okay. Is it possible that there isn't enough funding available there? I'm trying to figure out what brought the need for this bill if there was already this funding there.
That I'm not sure. I can tell you that there's plenty of funds available over the last 3 years. I have data over the last 3 years. We haven't exceeded close to the funding that is available.
Mm-hmm.
So whether an application was applied for by the agency that's requesting this or seems that this is a problem, I would encourage them to reach out to the Office of Highway Safety to see what funds are available.
Does the Office of Highway Safety operate proactively, reaching out, letting departments know there's money available and things like that?
That I don't know.
Okay. All right. Thank you. Seeing no further questions, thank you for your testimony. Is there anyone else wishing to testify on this bill who has not done so? Seeing none, I hear. Oh, you got to turn that card in, sir.
Good, have a seat. On your mic.
Okay, Mr. McFadden, go ahead.
Good afternoon, Mr. Chairman. Good afternoon, ladies and gentlemen of the committee. My name is Bill McFadden. I am the chair of the Select Board of New Boston, and I've reached out to my representative to introduce this bill. This started with a general discussion with one of the officers on duty while we were having our voting last November. We just started to talk about speeding. We have a large speeding problem in the town of New Boston. I commute from New Boston to Hudson daily, and I see it in every municipality that I drive through. People are they're crazy out there. So it was just a general discussion, and I started to talk with the officer about that. And he said he has the tools. We have radar, but we don't have LiDAR, which is laser. And he's like, it's too costly. I'm like, okay, so what can we do? And I'm speaking not just on behalf of New Boston, but other smaller municipalities where budgets are tight. We don't have a large commercial base in town, so it's residents that are footing the bill. And whenever police departments try to add items to their budget, everybody has, they get all worked up. So I started to think about, well, what about a possible grant program where some of the monies from traffic tickets can go into a grant, and municipalities can go to this pool and apply for monies for equipment. I spoke with my chief of police in town. He thought it was a great idea. We're not a poor town, but certainly not we have no commercial base in town. So again, it goes back to the funding of this. So we started to talk about what could it be used for: LiDAR guns, digital speed control devices. Because I can tell you, as a driver, when I see those speed controls, it always makes my eyes go right down to my speedometer. And if I see them just a few miles over, I will slow down. Those devices do work.
And by that, you're talking about those portable signs.
The portable or
radar.
trailer ones as well. And just it's simple things like that, I think that could help around the state to try to get traffic to slow down, because it really is out of control right now. And I'm just trying to do my part to see what we can do to try to curtail this.
And we appreciate it. Thank you. You heard the earlier testimony regarding NHTSA, the National Highway Safety. Have you or your town applied for any grants through them?
That I do not know, but I made a note, and I am certainly going to investigate that.
Okay. If you could, when you talk to your chief and you get feedback on that, could you ask him to pass it on, or you pass it on to your representative so we could get it back here?
Absolutely. Will do.
I appreciate it. Any questions from the committee? I would assume that a lot of your speeding problems are caused by those strange Space Force people that are stationed in New Boston, I think. Have you seen a lot of it?
Some are there, and a lot of the skiers that go to, we have Pat's Peak right nearby, and we have over in Francistown, we have the ski area too, and we see a lot of out-of-state plates. That's just.
Do you provide it, or does your police department provide any security or work in tandem with the base security?
Yes, we do.
And do you receive any funding back from the feds for that?
We do. We actually just had a K-9 program established, and they're funding that. So they're a very good partner with the community.
That's good to hear. Great. Thank you. All right. Seeing no further questions, thank you for coming today.
Thank you very much.
You're welcome. Now, is there anyone else wishing to testify who has not testified on this bill? Seeing none, I hereby close the public hearing. We reconvene at 2 o'clock. I'm hereby opening the public hearing on House Bill 592 and invite the sponsor to come forward and introduce this bill.
Thank you, Mr. Chairman. Mr. Chairman, my name is Representative Ross Berry. I represent the towns of Goffstown and Ware in Hillsborough 39. I'm here for the purpose of introduction for House Bill 592, which is about magistrates and bail reform. I don't need to elaborate to this body the saga that has been bail reform, but I do think we may be finally approaching, hopefully, the final chapter. So as we know, PR bail has been basically an adamant failure. We just had an incident where an officer was shot in an altercation with somebody who should have been in jail. One of my former constituents, as you know, was stabbed to death by a person who was out on double cashless bail. And the stories have become stranger than fiction. But I do think with the changes in Concord, in the halls of legislature, that we do finally have something that will put an end to this. So I have distributed to the committee an amendment that I worked with the Governor Ayotte's office on, and it has her support. It is Amendment 2025-0131H. So I'm going to kind of constrain my comments to that amendment versus the original underlying bill. The underlying bill was a full repeal because I felt that the statement needed to be made that the system doesn't work. But I also live in the reality that we may never see full repeal. So what this bill does in a nutshell, and I'll let people behind me who are well more versed in it and can answer your questions, answer those questions. But what it does in a nutshell is it takes what was working, the small parts of PR bail that were working, and it keeps it in place. But it gets rid of kind of the extreme examples of just letting people go. It ends the revolving door. So it has things in there like you're not going to get PR bail if you're arrested while already out on bail, if you violate a bond condition, those sort of things. It takes it from the basically automatic default to you need to prove that you qualify for it. So I know that this is going to be a long hearing. There's many members of the law enforcement here community hopefully in support of this. And I'm going to let the governor's office, if the chair will indulge me, let the governor's office and their representative come up and explain what's in the contents of this amendment. Thank you.
Thank you for bringing us this bill. The chair,
Put the amendment up here.
the chair calls Miles Matheson from the governor's office.
Good afternoon, Mr. Chairman, members of the committee. And with your indulgence, Mr. Chair, if we could also invite Tom Velarde, he's the director of the Division of Public Protection in the Department of Justice, up to testify with me if that's amenable to the committee.
That would be fine as long as you both filled out that pink card, or if you didn't before you leave, please.
Members of the committee, the amendment that you have before you is designed to protect our communities, protect law enforcement, and it is incorporating lessons learned in the bail reform efforts of the past 7 and 8 years. And as Representative Berry indicated, it's designed to stop a revolving door whereby repeat offenders are exposed to the community and committing crimes again, and it's tailored to that population. The governor supports this amendment. It should be no surprise to you that the governor spoke to a number of people about bail reform on the campaign trail, that she heard from many citizens across our state, and she has heard from law enforcement with their background, has an intimate knowledge of this subject area, and that this is an important issue to her to address, and is supportive of this amendment and this effort to revise current law with the lessons that have been learned in our past number of years. The primary focus is to ensure protection for our communities, for victims, and for our law enforcement officers by taking a common sense approach that focuses on repeat offenders by those who have previously committed offenses while on bail, who have violated bail conditions, or have failed to appear for their court appearances. So some of the lessons learned from our past efforts at bail reform is that current law is not adequately protecting our communities or law enforcement for that subset of individuals who repeatedly flout the law. You may be familiar with the governor's ride-along with a police officer who had his finger gnawed to the bone by an individual who was dangerous to others, dangerous to the community. As was just mentioned, there was a Bedford officer who was shot during a skirmish with an individual who had numerous failures to appear, including on a charge of possession of a dangerous weapon. And under the features of our current system, technically he was not detained because he hadn't hit the required number of failures to appear in the short enough time frame. So he was out and he seriously injured a police officer. The current law that has a 3 strikes rule for failures to appear is a permission slip to continue to ignore court orders and obligations to be responsive and to appear in our justice system. And current law prohibits judges from ordering detention where there's probable cause to believe that a person will be dangerous to themselves, to others, or to the community. So the amendment before the committee takes a common sense approach of trying to close those loopholes, to appropriately craft the standard, the threshold, the mechanism, such that a judge can protect the community, protect law enforcement officers, protect individuals who pose a danger to themselves or who have a demonstrated history of failing to comply with conditions imposed upon them. And that's really to stop the revolving door that we've heard about and that we see. Current law sometimes allows an offender, even where there is probable cause to believe that they pose a danger to themselves, another, or to the community, or has a history of violating bail conditions, either by ignoring bail conditions, failing to appear, or committing new offenses, back on the street. And you may hear from our law enforcement officers where they may have an individual such as that, and that individual may be released back to the street before the police have even been able to finish and file their police reports. That's not a system that's working. That's a system that should be addressed in order to prohibit that outcome. This amendment, judges have the discretion to be able to look in those circumstances and keep those individuals detained. Judges have discretion, one of the lessons learned, to be able to look at the financial conditions of an individual and to take those account such that the financial conditions alone are not going to have someone detained. But where there's evidence indicating that there is a danger or a history of noncompliance, judges will have that authority to detain those individuals. So listen to our law enforcement, listen to our communities, listen to those experiences and the empirical evidence that suggests that we need to be tailoring our approach to this subset of individuals. This is a common sense bail reform that will improve our system, protect our communities, protect our law enforcement. And it's not just anecdotal. There is empirical evidence that focuses and directs us to establishing a mechanism to focusing on this set of individuals who are high use or repeat offenders. So with that, and to speak to that point, I'd like to hand off to Tom Velarde, the Director of the Division of Public Protection of the Department of Justice.
Thank you, Attorney Madison. Thank you, ladies and gentlemen. It's a pleasure to be here. It's been a long 7 years. I have been part of bail reform discussions since their inception in 2018. And I think it's important for me to recognize the real work and effort that many of you in this room have put into improving the situation, both for people accused of crimes as well as for our communities. I want to emphasize, however, that there is another step that can be taken, and I believe that this governor's bill addresses that. Specifically, it has to do, as been said by the representative who's sponsoring this amendment, as well as Attorney Madison, that term we keep using, revolving door, I don't particularly like it. We are talking about human beings who may be having struggles, but the fact of the matter is they are coming in and out of the criminal justice system with great rapidity. In fact, our state sanctioned the Justice Center, Council of State Governments, to look at that very issue. And for a number of years, they have. One of the findings that they made in this report, which I'm happy to leave with the committee, is that the stories that you've heard, not just here today, but over the years, which have been sort of chalked up to being just random anecdotes, are not that at all. These are empirical studies that show there is a small percentage of the population who has been turned out again and again and again. They happen to be a very complicated subset of the population. They typically up to 70+% have co-occurring issues. But these are folks who are committing not violent crimes, they're committing property crimes, low-level crimes, and continuously getting rebailed. If you take a look at this report, you're going to see the millions and millions of dollars that costs the state of New Hampshire just in Medicaid. Not to mention the cost of just the constant rebookings. Not to mention the stories that you'll hear probably from my law enforcement colleagues here about the frustration of seeing the same people bailed and then constantly rebailed. And much like you, I was an elected official for 16 years. I had constituents calling me, asking me as a county attorney, why was this person just bailed and they're back out and they broke into my store? I'm a small business owner. I can't afford this kind of situation. How can this possibly happen when the courts of New Hampshire have bailed this person? This bill is designed to look at that very issue. It keeps so many of the other improvements that we've all talked about over the last 7 years and have collaborated on. But when you look at the three categories of what judges will be directed to look at, it really gets to the heart of who is likely to appear in that subsequent hearing, who is likely to remain safe in the community and keep us safe, and also balancing how many people can we safely keep in the community. We know we can do that, and that's why this is not a repeal of the PR system. We know that can safely be done. This bill strikes a really good balance to finally go after that subset that has been identified by an outside agency as being a real problem for the courts, and will treat them fairly, but will identify them in such a way as we can stop or put a stopper, if you will, in that revolving door. That's the exciting aspect of this bill, and look forward to the further discussion and for your consideration of it.
Thank you, gentlemen. And I'd like to extend thank you to you, Mr. Velarde, for recognizing the work that we did put into this many, many hours last year to come up with a compromise bill to get some progress forward. And I look forward to looking at this and making further progress as well. I would also like to say that I'm intending to make a subcommittee, and it probably take about a week or so. And I'd like both of you, if you are available, to work with us and with the court. It's my understanding that this wasn't socialized with the court first before it was submitted to us, and they may have some concerns, not with regard to the issues of who should and should not be held, more about logistic type things. So I think that shouldn't be a problem for us to overcome and get a good piece of legislation out. Any questions from the committee? Seeing none, thank you both for
Thank you, Mr. Chairman.
coming today. The chair calls the Honorable Mr. Rua, Mayor of Manchester.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Jay Ruhe, Mayor of Manchester. I also want to extend my thanks to this committee. Being an elected official myself, I recognize how difficult it can be when you're working through difficult topics like this. So I appreciate all the work that the previous legislature and governor did to get us to this point today. I also want to take a moment to thank Chief Marr and Assistant Chief Louis, who came up today from Manchester, also to show their support for this effort to further work on PR bail. As mayor, my most important job is to keep the city safe. And the safety of our city is absolutely non-negotiable. And the simple truth is that when people are bad actors, when they are engaging in illegal activities, they need to be held accountable for their actions. I would give one example. In my past life, I do believe that the criminal justice system can be rehabilitative. And I do think that there are opportunities to take an individual who may be going on a bad path and reorient them. And I would use my own example in my own life as testimony to that fact. I've been very open about the fact that I've been in recovery for 14 years, and but for my association at the time with the criminal justice system, I don't know that I would be sitting in these seats. So I think this part is twofold. One, there are bad actors on the streets that have no place being on the streets of the city of Manchester or municipalities in the state of New Hampshire. Additionally, I do think that there are opportunities to take an individual and help make them a better person and a good, productive member of society. The bottom line, though, is that if you are arrested for committing a violent crime, particularly if you are out on bail, you have no place on the streets of the city of Manchester or other municipalities in our state. And I think we had talked a little bit about this already, but the challenge that we run into Manchester is the violent and the repeat offenders specifically. So in speaking with our police department, I just want to give a couple quick examples of what we experience in the city of Manchester. So these following examples highlight this problem. So individuals who were arrested for serious crimes, released on PR bail, only to be rearrested for the following crimes: murder, stalking, stabbing, assault, and armed robbery. I appreciate the opposing argument on this, that we do not want to be locking up individuals for petty crimes or things that they're doing to subsist. These are not those kinds of crimes. And this is what we're dealing with in the city of Manchester. And this isn't just anecdotal. We have strong numbers to back this up. And our police department has done an extraordinary job at being able to compile this data to make, I think, a compelling argument in favor of further reforming bail. In 2024, there were 2,971 adults arrested in the city of Manchester. These individuals accounted for 4,551 arrests. The gentleman before me spoke about this. That is a smaller subset of the population that is committing an egregious amount of crimes in the city of Manchester. These numbers don't add up because 27% of them were arrested more than once. So of the 2,971 individuals arrested, 715, or 24% of them, were out on bail at the time of that arrest. So this creates multiple problems. Number one, obviously for our city, who is continuing to experience or become victims of these crimes, but also for our police department. You know, not unlike other departments across the state, we roughly float around 20 vacancies. So we have fewer cops, and we're asking them to do more with less because they're continuing to have to arrest the same individuals over and over again. This is not sustainable. We cannot continue down this path here in the city of Manchester. There could be nothing so transformative for our city than to remove nearly 1,000 criminals from the streets of Manchester. So in addition to the change in the city, this would have a dramatic impact on law enforcement, as I spoke to. The morale, obviously, in the city of Manchester is high. They are always going to do their jobs. But this certainly creates a barrier for them, and it makes it more difficult to do the jobs that they were trained and assigned to do. So I really appreciate the opportunity to be here today. I truly sincerely appreciate the work that this committee does. I recognize how difficult the nature of your jobs are, but I would really encourage you all to continue down this path. Let's find something that we can work with. Again, there would be nothing so transformative for the city of Manchester than having something like this take effect, where we could potentially remove 1,000 criminals from our streets. So thank you so much.
Thank you, Mr. Mayor. Seeing no questions from the committee. Thank you.
Thank you.
The chair calls Attorney Aaron Cregan from the New Hampshire Court.
Good afternoon, members of the committee. Aaron Cregan, General Counsel for the Judicial Branch. And surely for those of you that are returning, I'm a familiar face, and we saw a lot of each other when we were discussing bail last year, and I appreciate so much the opportunity to work with you. As you know, there were a number of changes that the judicial branch made in order to effectuate the will of the legislature as expressed in HB 318. One of those was the hiring of 3 judicial officers who quit their jobs, became magistrates, and have very extensive backgrounds as police officers, as defense attorneys, and as prosecutors that prepared them well, underwent extensive training as well. I see this amendment, and I think there are many positive changes in the amendment, but I believe that this preserves a portion of the underlying bill, which in relatively short order abolishes those positions. What I might suggest to you is that they were appointed to 5-year terms. You may wish to sunset the position at the end of the terms as opposed to immediate abolition, in recognition that these judicial officers did accept that position for the purpose of implementing your design, your will. They are public servants, or just have mercy on me as someone who defends the branch from employment actions. But that is something that I put to your consideration, even if you determine that that's not something you do want to preserve, whether you would at least like to consider sunsetting at the end of their current term, which is a 5-year term. The magistrates, although they are highly qualified and highly trained, cost about half as much as a full-time judge. I think it's actually less than half. And they perform many, many routine functions that take up judges' time and push out calendars for other cases. The circuit court retook the initial proceedings relating to felonies relatively recently that came with no additional staff or resources. The help of the magistrates in processing many of those preliminary hearings is very valuable in defraying costs for the court and moving some of those proceedings along. So I put that to your consideration. It is, of course, always the determination of the legislature, the way to move forward, but I at least want to raise those questions for your consideration. In my first review of the original draft of this bill, I haven't had an opportunity to work with my friends and colleagues in the executive branch on it, but I look forward to doing that. I did note that there were some potentially drafting errors. For example, I saw that detention was accidentally eliminated as an option on first appearance, and that the assumption that a victim would not have to testify in person was accidentally eliminated. I assume that those were accidents, and I see that those have been corrected in this version. I haven't had a chance to review it extensively, but there are a couple relatively logistical minor issues that may be worthy of the legislature's consideration. For example, another section of this bill, which doesn't appear in this amendment, abolishes a provision that times first hearings that typically saves a lot of time in the morning docket. And I'd love to speak with the sponsors about what their legislative intention is in doing that, and see if there would be a way to effectuate it that would not require morning hearings to all be stalled while we're waiting for attorneys, which is the original reason that the legislature had passed that change. So there are a few logistical matters, but of course, if those of you that worked with me last year know that the judicial branch certainly understands that we implement the laws that you write. The policy determination is yours. We will work with you on whatever it is that you determine is best to do. There are no two states that have identical bail laws. There is a very wide range of policy solutions that the judicial branch can implement. And we're very, very happy to work with you to see that we can implement your design and your policy attention.
Thank you. I can, speaking for this committee as a part of the legislature, it's important for us that when we craft legislation, that the people that we ask to do are able to carry it out. So that's why I think it's very important that we get together with the court and the sponsors and make sure that it's actually doable and we do it right the first time, because I swear I'm not going to deal with bail again next year. This is it. Having said that, any questions regarding the court? Seeing none, thank you for coming today. The chair calls Melissa Davis.
Still a novice. Good afternoon. Thank you for the opportunity to speak. My name is Melissa Davis. I'm here on behalf of the New Hampshire Association of Criminal Defense Lawyers. I'm currently the director of the Criminal Practice Clinic at UNH Law. Prior to joining UNH Law, I was a public defender in New Hampshire for 15 years. So I've been a criminal defense practitioner for 20 years. I'm not here on behalf of the University of New Hampshire. I'm here on behalf of the New Hampshire Association of Criminal Defense Lawyers. I guess the first thing I'd like to say is obviously, when bail reform first came about, obviously I was here during that practice, we understood the main focus and the primary focus to be making sure that people were not held on low amounts of cash bail. They were not held on low amounts of cash bail for minor crimes, such that poor people were being held in jail for significant sentences beyond anything they would ever possibly face as a sentence in a case, simply because they did not have the means or the money to post bail in a matter. That substantially has gone away. I don't have clients in those situations due to bail reform. That's significant in this case and matters because of the efforts of this legislature and the work that's been done on bail reform. I understand, and I've followed, obviously, as a practitioner over the years, the number of bail, the number of amendments that have come to bail reform issue and the reasons why. And I actually appreciate Attorney Velarde raising an issue here and agree with him. We practiced together a long time. And so, we know probably some of the same people that we're talking about here. But when we're talking about this population that is sort of the ones that are consistently coming before the courts, that are consistently being arrested, he used the term co-occurring disorder. And I just want to make sure that everybody understands exactly what that means in this situation. These are people who are suffering from likely both substance misuse disorders and significant mental health conditions. These are people who are, we are trying to help in our communities. And I would note that, the battle on the opiate crisis, while long and hard, we are gaining ground. The number of overdoses are down in this state substantially, and it's making a significant difference. And so I would say that this population is challenging, and we do absolutely understand that in this situation. But these are folks who are struggling with these things and could greatly benefit from the services in the community that are being provided so far in terms of community mental health agencies, as well as access to treatment. The other thing I'll say is overall, my understanding is violent crime is down in New Hampshire. And so this response, while I understand the number of, people here who may be sharing individual stories, overall, the picture is that violent crime is down in New Hampshire. This committee last year as well put a lot, I'm aware, of work into a significant compromise bill. And I would absolutely call it a compromise bill in this situation when looking at, what went into it. The thought that specific crimes and specific violent crimes were identified as really high risk in this situation, and the significant consequences of people violating bail when charged with those types of crimes is understandable, and it was probably inevitable that bail reform would lead to that kind of legislation for those types of crimes, and so absolutely understandable. But the concern is that, at this point, we're going to get back caught up again in people being held on amounts of cash bail that they cannot post because they do not have the means to do so, when people who do have means and maybe, have committed the same crimes or have the same criminal history or have the same, underlying conduct can be released in these situations. We are concerned, obviously, in the situation, we understand the failures to appear and the concerns over the failures to appear by the courts in these programs. There have been efforts by the courts to deal with this. And so it's my understanding there's a pilot program in Rockingham County to start making text messages available to individuals in order to remind them of their court dates. These are transient populations who oftentimes don't get mail and oftentimes are unable to access anything other than maybe a text message system when they have a Wi-Fi connection, which fortunately is around. So these are individuals who can be reminded by the court by some pilot programs that are coming into place. I would say additionally, it's my understanding that there's a new system that may make information about who exactly is on bail become more available by entering it into the NCIC system. That's incredibly important because my experience in all of this is every iteration of bail reform that's been concerned about people committing crimes on bail, the law has already provided the ability for people's bails to be revisited, amended, and revoked should they violate their conditions of bail. The problem is finding, is initiating that process, making that underlying information known, and I think alleviating some of the work on prosecutors in these situations. That kind of system would make it known to police officers and prosecutors who is on bail in individual situations, and make it more likely that, the types of motions that have always been available and are currently available under this law can be filed with a court and heard by a magistrate or judge to make a determination about bail in this matter. Our position is that, the bill that came through last year, through a lot of hard work by everyone here, is just getting started. It's January 29th, and it started January 1st. These magistrates just got to work. We are currently, working with them and seeing, what this system produces. To not give it the opportunity to do so, we feel is sort of unfortunate because it's a bill that really tackles all the complications that bail reform probably did bring about. Thank you for the opportunity to speak.
Thank you for coming to see us today. Chair calls Major Bashaw.
Turn it off. Good afternoon. Thank you, Mr. Chair. Thank you, members of the committee. For the record, I'm Major Chris Bashaw of the Rockingham County Sheriff's Office, and we are here in support of the bill with the amendment as proposed and supported by the governor's office. There are you're going to hear stories of some of the more egregious cases for some of the very violent crimes where people have been out and reoffended. I'm going to speak more from a unique perspective of the sheriff's office, and we get all the Superior Court warrants that come from the Rockingham County, New Hampshire, and we have to enter those, and we go out and try to effect those. And at any given time, we usually maintain anywhere between 1,000 and 1,200 active warrants from the Superior Court. And we track these folks down all over the county, all over the state. We extradite them from all over the country, depending on the seriousness of the crime. And since a lot of the initiatives of bail reform, there have been quite a few repeat offenders and frequent flyers who really just, they've obviously been able to manipulate the system and fly in the face of law enforcement. It's very disheartening when you see felony level cases and then new warrants are coming out with judges' orders to arrest for failures to appear, and they come to us and they're already preset with a personal recognizant bail even from the court on these repeat offenders. And these folks are treating that, it might as well be a late payment notice for your credit card to some of these folks, where they actually laugh in the face of the deputies when they show up and they say, hey, should I just have my ride pick me up in 30 minutes? We both know I'm going to be out of here soon. So it's very disheartening. Obviously, our folks always want to go out there and do their job, but when they continue to see these folks can create some dangerous situations as well, because now we do have an arrest warrant that's set with a personal recognizant bail, but we still have a duty to go effect that arrest warrant. And some folks don't want to be arrested on that, even though they probably will be processed and out of there and bailed again within 30 minutes. And it's created situations that's put defendants at risk where we have to forcibly remove them. They resist arrest. They fight with our deputies and local police officers. So there's a lot of situations where it's created these problems, and it's really disheartening from an enforcement standpoint to do all this work and tremendous resources as a taxpayer. It often flusters me to see that we will fly all over the country for some of these serious offenses, go through the process of extradition, governor's warrants, flying out with multiple deputies to bring them back from Texas, California, Florida, and other states. And then, pretty shortly after, they're released again on personal recognizant bail, and we know that they're in the wind. So I know you're going to hear from some folks with some specifics, some very egregious stuff, but I just really wanted to speak to some of the specifics that affect the sheriff's office and all those judges' orders to arrest for violations and failures to appear that are coming out on a very regular basis. And it is disheartening to law enforcement in general. And as everyone knows, we have a national recruitment and retention issue as it is. And the last thing we want to do is disenfranchise those motivated law enforcement officers that want to make our communities a safer place to be. Thank you.
Thank you for sharing that unique perspective with us, Major. I think I need to talk to you about a budget.
Yes, sir.
You stick around when we're done. The chair calls Amanda Azad.
Okay, let's see if the mic is right. Okay. Amanda Azad, Policy Director at the ACLU of New Hampshire. Chairman, committee members, thank you for your time. Many of you know a great deal about bail, and I appreciate your work in this space. I have not had time to review the new amendment, and I'm going to try to respect the time of the committee since this is a very busy hearing. So I've cut back a little bit of what I had planned to say. But first, I'd just like to step back for an overview of why the bail process is key to a just criminal justice system. Bail is the process that determines whether someone accused of a crime will be incarcerated before their trial. Bail is supposed to serve two purposes here in New Hampshire. One, to ensure that someone accused of a crime will appear in court, and two, to ensure that people who are a danger to the community are detained even though they have not been convicted of a crime. Until bail reform in 2018, thousands of Granite Staters were incarcerated pre-trial each year, not because they were a danger to the community, but simply because they could not afford to pay their bail. If you could afford bail, you had a very different experience. I just want to reflect on how far we've come. Study after study shows pretrial detention increases recidivism rates, which means a person is more likely to be arrested for a new crime. We do not want that, of course. Pretrial detention has a host of other issues. It makes it more likely that innocent people will plead guilty. People lose their employment, their income, even their housing. People have their liberty taken from them before the criminal legal process has even begun. Being detained for any more than a day is a traumatic family disruption. So the money bail system, the one that HB 592 initially, and maybe still, hopes to return New Hampshire to, is a system that fuels widespread wealth-based incarceration. For context, pretrial incarceration caused unaffordable bail. For the context, pretrial incarceration has caused unaffordable bail as the single greatest driver of convictions and is responsible for the bloating of our nation's jail and prison populations. Meanwhile, wealthy people, as was pointed out earlier, accused of the same crime can buy their freedom and return home. So with all that said, New Hampshire is better for its work to end wealth-based incarceration. Bail reform is an important piece, making our criminal legal system more about justice and ensuring each person in New Hampshire feels that their liberty and freedom and legal rights matter. Needlessly incarcerating people for several days or with high bail, not based on ability to pay, is detrimental to families, communities, and cost taxpayers a ton of money. Merely being arrested is not supposed to result in a person being incarcerated, with limited exceptions, such as they are a danger to our community. Our current process in New Hampshire has that exact piece included. Under our current system, we are in a good place. HB 592, we are stepping far back into the past and throwing out a lot of good that's been done here. I also want to acknowledge the work done by this committee. Progress on bail last year was the result of years of work by this group of people. It was months of bipartisan negotiations and a bipartisan result. There were work sessions, there were field trips, there was stakeholder buy-in, there was genuine real input from law enforcement, from courts, from stakeholders. It was a very serious process. Now we're only 7 or 8 months out of committee of conference. We're only 6 months from the governor signing it, and we're less than a month from fully being enacted. And we're having this conversation about potentially cutting us back several years. We need to let the new changes take effect. We need to let the magistrates who have a 5-year term do the work that the legislators asked them to do. And I just want to remind everyone that the magistrates is a cost-saving system as well. Saving money by not incarcerating people in jails for several days or more, that adds up very quickly. But also, as mentioned earlier, magistrates are paid less than judges. So if you're going to get rid of them, you're going to have judges doing the work at a higher cost. Anyone who's a danger to the community can be held. Currently, if folks violate a term of their release, there are options to hold them, and decisions around bail may be appealed by both sides. The system works, so if it could have more than a month to operate, that would be best. And lastly, I just want to, let's appreciate that New Hampshire is incredibly safe. It is known as one of the safest states in the country repeatedly. Across the board, according to the Department of Safety's website, crime was down from 2023 to 2024. So I want to be clear, there is no wave of crime that has overtaken the state that merits tearing up a brand new bipartisan deal on bail. In fact, since bail reform has been enacted over the years, New Hampshire continues to get safer. Looking at the data all the way back to 2018, the first year of bail reform, crime has continued to drop. We are continuously ranked as one of the safest states in the country and do not need to rip out bipartisan criminal legal reform efforts out of our laws and go backwards. Bail reform has made our state better over the years. Please don't go backwards. Thank you for your time.
Thank you for sharing that with us. The chair calls Pat Sullivan.
Good afternoon, Chairman Roy and members of the committee. My name is Patrick Sullivan. I'm the Executive Director of the New Hampshire Association of Chiefs of Police. I've been actively involved and currently serve in law enforcement for the past 43 years. I retired as the police chief in Goffstown. I am here today to support HB 592 and its amendment and for the New Hampshire Association of Chiefs of Police. For the most part, this amendment restores the statute to the bail back prior to 2018. The purpose of bail has been a legal process to allow the defendant to be released from jail while awaiting trial. The other purpose of bail is to ensure that the defendant appears in court and does not pose a danger to the community. Since the legislature made sweeping changes to bail reform in 2018, signed by the governor in 2018, there has been a considerable frustration by all of law enforcement about those who are not being held, who are a danger to the public and the community. While well-intended, SB 556 went too far. Since 2018, there have been many examples of how bail reform has not worked and several changes made to attempt to correct that statute. The New Hampshire Association of Chiefs of Police appreciate the governor bringing this bill forward, and we look forward to working with the committee on this bill. Thank you.
Thank you, Chief. The chair calls Chad Lavoy.
Good afternoon, Mr. Chair and committee members. My name is Chad Lavoy. I'm a major with the State Police, and I'm representing the Department of Safety from New Hampshire and the State Police as well. And I'm here to offer testimony in support of this bill. And I'm not going to repeat what my colleagues have to say, but I'll make it brief on where we stand as an agency. This change simplifies the bail process and brings it back to where it was prior to 2018. Our bail commissioners are well educated and experienced in the process of representing the courts while determining amount of bail. Our agency has trust and confidence in their ability to properly determine that bail when they look at multiple different reasons, whether that's based on the level of crimes, the history with the defendant, failure to appears, criminal history, are they out on bail right now? And most importantly, are they a threat to themselves and to public safety overall? This amendment will save us time, resources, and money as an agency. Already stretched thin, our important focus right now is public safety and being out there in a proactive enforcement measure as a state agency. We cover multiple different courts in all of our troop stations. We have a process with our prosecutors and our court support staff and a trooper in each troop that's designated to those courts. They work during the week, Monday through Friday, as well with our prosecution staff. When there is something on the weekend that needs to be done, if a defendant has a hearing on the weekend, now the way it's set up, it's very taxing on us with resources, getting those reports, if it's from a different shift, reviewing those reports, and then having that hearing during a designated time is very taxing on our agency when we like to best utilize our resources out in the public view, in the public eye, enforcing the laws of the state. Our goal is to ensure that bail is appropriately being set by the bail commissioners and the courts in a consistent and effective manner to ensure that those that are a danger to themselves, us in law enforcement, and the public are held accountable. Again, our main focus is public safety, and it's for these reasons and several that will be stated by my colleagues today that we're in support of this amendment.
Thank you, Major. If I may ask, If you're aware, where does the information system stand right now as far as bail, as knowing who's on bail? We allocated a significant amount of money to that last year, and I went to every hearing to make sure that it stayed in there. Can you tell me where it's at?
I don't have an update for you right now on that, sir, but I can certainly look into that and get back to you on that.
I would appreciate it. Thank you.
Absolutely.
See nothing further. Thank you for your
Thank you, sir.
testimony. Is there anyone else wishing to testify on this bill who has not done so? Seeing none, I will hereby close the public hearing. I will be appointing a subcommittee, and that will be out before the end of the day. Thank you all. Members, we're going to be in recess for 15 minutes before we take up a few bills for executive session. Thank you, everyone. I am now opening executive session on House Bill 75, and I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 75.
I'll second that motion.
Thank you. Would you like to speak to your motion?
Sure. Unfortunately, the sponsor was not able to come testify on this bill. And our understanding is like usual, we have several cannabis bills coming towards us this session. And our hopes is maybe one of those may address what this situation is, or maybe they're going to put this particular language with one of those other bills.
Thank you. Would you like to speak to your second, Representative Pro?
No, thank you.
Thank you. I would just say that it is true there are, a matter of fact, we have a couple more cannabis-related bills. And I don't think that it is that high on either party's priority list this year. So I don't see us spending a lot of time on that. And as I said, the prime sponsor, he may have been traveling. I'm not sure, but someone on the list could have come and no one did. So we give what we get. Any other comments or questions or discussion? Yes, Representative Murray.
Thank you, Mr. Chair. I will be voting for this today because I always vote for expansion of cannabis in the state, and I do believe it should be legalized and that we should have home grow, and hopefully we will see something come out of the State House, whatever it may be.
I admire your principled stand. However, we are going to roll over you. Thank you. Representative Scher.
I'm going to join Representative Murray for the same set of principle.
Very good. I'd ask the clerk to call the roll. A motion on the floor is inexpedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Pruitt?
Yes, please.
Representative LaSalle's?
Yes.
Representative Devoyd?
Yes.
Representative Gagny?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschanel?
Yes.
Representative Barry?
Yes.
Representative Harriet Gathright?
No.
Representative Muse?
No.
Representative Newman?
No.
Representative Murphy?
No.
The clerk votes no. Representative Newell?
No.
Representative Scheer?
No.
And Chairman Roy?
Chair votes yes.
9-7.
9-7, the motion ITL passes. Who will be writing a minority report?
Allie.
Ally? If I could get it by the end of the weekend, please. And Representative Rhodes, you'll write the majority.
Sure.
With that, I close the executive session on House Bill 75. I open the executive session on House Bill 91 and recognize Representative Prue.
Ought to pass. Which one are we doing?
91.
91? Which one's
91. That was the correct motion, I believe.
Not
Yeah.
not 291.
90.
Oh, the fireworks.
91.
Yeah.
91.
Sorry.
And Representative Paquette? Second?
Okay.
Second.
Okay, motion was seconded by Representative Paquette. Would you like to speak to your motion, Representative Prue?
No, I think it's pretty simple. It's just removing, I guess I will talk. It's just removing the necessity for a fire department detail to be there from the moment the truck arrives with the fireworks until they are all gone off and put out. It gives discretion to the fire department when they believe they need to be there, and only that.
Thank you, Representative. Representative Paquette, would you like to speak to your second?
No, thank you.
I would just add that this is a cost-saving measure for municipalities who pay for these firemen to stand by, sometimes overnight while fireworks are on the ground waiting to be lit. I think that, if I'm not mistaken, the fire departments themselves have supported and asked for this bill. Is that correct?
I believe so.
Yeah, so that's where that's at. Any further discussion? Seeing none, I ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes?
Yes.
Representative Pruitt?
Yes.
Representative LaSalle's?
Yes.
Representative Devoyd?
Yes.
Representative Gagny?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschanel?
Yes.
Representative Barry?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Shear?
Yes.
Chairman Roy?
Chair votes yes.
16-0.
16-0. Any objection to consent? Seeing none, it'll go on the consent calendar. With that, I hereby close House Bill 91. Representative Prue, if I could get a report by the end of the weekend, please. With that, I open the executive session on House Bill 183, and I recognize Representative Prue for a motion.
Ought to pass.
Second.
Seconded by Representative Paquette. Would you like to speak to your motion?
Yep, this bill works to remove the unfunded mandate of paying overtime when the call happens close to the end of their shift, which is a rare occasion. And this will probably be just used for routine calls. Any significant call, they get done automatically within 24 hours or even before they leave. So we'll still pay overtime for those, but it just a cost saving measures on the routine calls.
Thank you, Representative. Would you like to speak to your second, Representative Paquette?
No, I agree with what he said.
Thank you. Representative Prue, to the best of your knowledge, was the department or the state fire marshals, were they notified of this bill?
Yes, they knew about it.
And did anyone come or notify you that they were against the bill?
They said they weren't happy with it, but apparently not enough to show up.
Okay. Excuse me, go ahead. Yeah. No, he had discussed an amendment, but I think he just decided it didn't need it. It wasn't a key amendment, I don't believe. I think that there's saving something for possible use in the Senate, if you follow that politics. Yes.
I think the Department of Safety did submit online testimony.
Yeah.
Okay.
Do we have that?
I have it digitally.
Is it long?
It's not super long, I don't think. Basically just says that the national trend for many states is now requiring EMS records to be submitted to the states within 24 hours of the event. In a recent meeting of the National Association of State EMS Officials, an on-the-spot survey of the 20 states reflected that 50% of them had a 24-hour or less requirement. Of the New England states, 4 out of 5 required 24 hours or less. In addition, New York requires submission within 4 hours. So New Hampshire, Maine, Vermont are all 24. Rhode Island is 2 hours. New York is 4 hours. Connecticut is 3 months. Massachusetts is 7 days. This letter strongly encourages all states to have requirements for data submission within 24 hours. Strongly recommended documentation by legal experts to reduce the likelihood of omissions and or errors in documentation. The state's EMSIR software includes mechanism for hospitals to receive these reports, which may be needed in a timely manner. Some hospitals stipulate timeframes for data submission in their medical resource hospital agreements with licensed New Hampshire EMS units. EMS is also part of the healthcare system. Its patient records are medical records like any other part of the healthcare system. It's the
Who's that from
basics.
exactly?
The division of... It's from the Department of Safety. It says Division of Fire Standards and Training and Emergency Medical Services.
Representative Prue, would you like to address any of the comments made by the Department of Safety and Fire Safety?
That's nice that they have, they want 24 hours, but unless they're paying my overtime, that's an unfunded mandate, and I don't believe we support those.
Thank you. Seeing no further discussion, go ahead. Raise your hand high.
I don't think I can support this. When we had the conversation, I believe at the time that there was supposed to be an amendment that basically said that if it was a Delta or Echo, it had to be done immediately. You couldn't wait the 24 hours. We even talked about if letting the supervisor make a decision on some of those calls. But I know that I asked for 5 days versus 7 days. But on the same token, if it's Echo or Delta, then it should be 24 hours. And I thought we were going to see an amendment that basically said just that.
Would you like to see the amendment?
With such an amendment, would you support it?
Yeah, we said that before.
Let me see, how would we do this logistically?
Well,
And
my,
Nancy had, yeah.
just so you know,
I'm
my
thinking-
thought was I was gonna leave it this way, so that when it got to the Senate and the state finally showed up and was screaming and hollering, I would have some bargaining chips. So
what I
that's
was
why
trying
I
to
was
say.
leaving it this way. But
Yeah, you can hold on to it. We'll carry it.
I think I'm gonna do that because I'm pretty sure eventually the state will show up. The thing that gives me no motivation, sure, they did online testimony, but they couldn't be bothered to show up, so obviously it's not that important to them. So that's the way I see that.
Yep.
Thank you. I'm not sure why they didn't show up. It would have been nice to see them here and have their input, but they clearly stated and shared some information regarding other states as well. I know I had raised the issue of, I thought it would be important to have at least the Delta and Echo calls done routinely.
I'm
like
gonna
once a
tell
year.
you, that happens without us doing this.
Yes, but should we change it? We're saying they no longer have to be. And anybody that could choose for whatever reason not to, they'd say, look there's legislation there, I don't have to. So I get it. And I think most people doing their job are going to do the right thing. So I would not have objected to the bill if it was Delta and Echo calls were done within 24 hours and the remainder were maybe at the discretion of the supervisor. But I don't think I could support, I get the overtime savings, but I think that's something that management can figure. And it sort of bothers me to legislate like policy and procedures within a department when the input that they've provided is consistent with other states and this bill really isn't. So just my thoughts.
Thank you. So when it comes back from the Senate and that amendment is on it, then you'll be supporting it, right? There we go. See, everything works out. Representative Scher.
I was thinking maybe we could do the Delta Echo amendment here and save the 5 days for what happens in the Senate, just as a, it'd save a little bit of a bargaining chip, but,
I'm gonna roll.
Looks like he's pretty planted.
Ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yep.
Representative LaSalle's,
Yes.
Representative DeVoyd,
Yes.
Representative Gagny,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschanel,
Yes.
Representative Barry,
Yes.
Representative Harriet Gathright,
No,
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Newell,
No.
Representative Shear, Chairman Roy,
Chair votes yes.
9-7.
9-7. Play the lottery. Those are the numbers this year. Representative Prue, again, a report by the weekend, please. Who's going to do a minority report? Okay. By the end of the weekend, if you don't mind. Let me see. That's Nancy Murphy. With that, I close the executive session on House Bill 183. I open the executive session on House Bill 416, and I recognize Representative Samarone Deschanel.
Motion to retain.
Second.
Motion to retain made by the Representative Samarone Deschanel and seconded by Representative Rhodes. Would you like to speak to your motion, Representative?
Yes, I don't believe that this legislation will actually help reduce the cyanobacteria plumes. I think that we're just expanding basically state power into people's properties. I don't think that this is actually going to get where we're trying to go with it. So wants to solve one problem. It's a punitive solution, but it's not actually going to help us reduce the cyanobacteria.
Thank you. Representative Rhodes, would you like to speak to your second?
Sure, Mr. Chairman, thank you. The representative is correct, and I would like to state, I agree what was stated at the hearing. I certainly do not think that people should be putting their leaves, their yard waste into a river or into a lake. I also think that we talk a lot about education and how things are enforced, and there was a lot of questions that were not able to be answered at the hearing, and one of them was enforcement. I think that this could probably be dealt with education, and I would like to go that route. And I also agree with my colleague when he mentioned about environmental legislation and that forth. That might be the better route to go. So I think if we retain it, we can see if we can get any input on that and take it up over whenever we take this up, a summer or whenever that would be.
Thank you. And that's precisely why I did not want to ITL this bill. I do think that it has worth. The thought of somebody dumping stuff into a lake, grass or leaves, just really makes me unhappy. So I think that we need to look at, is this the right way to go about that, or should it be part of a bigger picture? So I actually do want to look at this over the break and learn more about these cyanobacteria thingies myself, because I don't know a lot about them. Any further discussion? Seeing none, I ask clerk to call the roll. Motion on the floor is to retain.
Vice Chair Rhodes,
Yes.
Representative Prue,
Nope.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschanel,
Yes.
Representative Barry,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy.
Gerald's yes.
15-1.
15-1, the motion carries. Any objection to consent? Hey, you objection consent?
No.
Okay, it will go on consent. If you could give me just a little blurb by the weekend, please. Let me see your report. Great.
Mr. Chairman,
No, it
I
doesn't.
don't believe retained bills go on a consent calendar. I think they're just retained by the committee.
Yeah, I think you're right. I forgot it was a
Yeah,
retained.
it is
Yeah,
retained by the committee.
but we still need a report to go on a calendar. Yeah. All right. With that, I hereby close the executive session on House Bill 4. Wait a minute.
Uh-oh.
Before I drop the hammer.
I was gonna say, retained isn't the report right now.
Oh, it doesn't.
Yeah, thanks.
No, we're
Ever?
holding on to it.
Okay.
It's
All
not
right.
going anywhere.
It's closed. Bill's retained, and you get out of the report. Magic. And with that, I open the executive session on House Bill 196. I recognize myself for a motion. I move inexpedient to legislate.
I'll second that.
Where's the bill? Stand by.
No, you, it's next.
Mr. Chair.
This was if I could please, this was, I just made a grievous error. This bill was not, this bill was accidentally put on here, was not supposed to be here. I withdraw my motion to, ITL. Who made the second?
I'll withdraw it as well.
It's withdrawn and that
I'm a nice guy.
executive session is hereby closed. I open executive session on House Bill 291 and recognize myself for a motion on that one, and I say ought to pass.
Oh, and I'll second that.
Wait, we're on an amendment.
Yep, you do. It's a, should be,
Yeah,
I
it's
put
on
it
the
in desk.
table, right here if you want to see it.
Okay.
Yes. Sure.
That's good to do it.
Mr. Chairman, Mr. Chairman, you don't have to withdraw your motion. You can just move an amendment on top of a not to pass motion.
Yeah.
Okay, thank you.
I'll
No.
Second.
That's me.
Thank you, Mr. Chair. I'd like to move amendment number 2025-0156H. Representative Leon and I agreed that there was the violation, removing the penalties that were in law currently, and as has been mentioned about other environmental legislation, part of the way to encourage citizens to be good stewards of our environment is education. We also spoke with I'm trying to think of the person from the Lakes Association, and they agreed that part of the information that they provide to property owners around lakes, it includes things like changes in law. This amendment changes the penalty, the penalties, and would change it to should a person or the corporate agent. So if a person hired, just say, I don't know, ABC company, upon that first initial incorrect application, either the wrong fertilizer or fertilizer incorrectly applied, they would receive a warning for the first offense. Both the homeowner and the agent that did the application. The second time, they would be guilty of a violation and subject to a $250 fine per acre, just for the second offense, and a misdemeanor for third or subsequent offense. There is a huge cost to tourism, lakes, our fish. I know there are landowners that have summer camps around lakes, and they can't have kids swim in the water if there's cyanobacteria. So this would go a long way in reminding people, and I think people try to do the right thing when they know about it. And I think that the Lakes Association would do a really good job of helping spread the information and around this proposed amendment.
Thank you, Representative. Representative Prue.
So I agree with most of that, except for the agent part, right?
Yeah.
If you're a professional landscaping company, you should know this. So I think they should get a violation for a shot, right? Joe Q citizen, I'm okay with a warning the first time, violation the second time, and the rest of that. But I'm thinking the agent, who's a professional, should know what they're doing, and if they're doing it on purpose.
Representative Newman.
Yeah, I was going to say, I would think that
Just throwing that out there.
having the fine, $250 doesn't sound like a big deal, but if you're a large company and you're doing a lot of lakefront homes, you could rack up a lot of $250 fines in one day.
Sure.
And essentially get to number 3, a misdemeanor, very quickly. So I understand, and I agree that those people that citizens entrust to do the right thing have somewhat of more of a responsibility, but I feel like if this would release any chance of, well, it's the homeowner's fault, they told me, or the agent saying, whose responsibility is it? It takes it all out, makes things consistent. There's no unknowns. And I think when a company, is known as violating this, it impacts business as well. So I think for simplicity's sake, it's probably.
Representative Newman.
I just have parliamentary inquiry. You're going to restate the motion and all of that? so
Yeah,
we know
I'm
where
going to
we are?
sort that
Thank
out
you.
in a minute. This is why I chose criminal justice, because we're always steeped in manure.
No.
Okay, so right now what we're going to be voting on is a motion to adopt.
Wanna
What?
respond? Never mind, just vote on it.
Okay. It is getting close to 4 o'clock. We're going to motion to adopt the amendment, correct? Yes. Who did? Oh, I'm sorry, Rich. Did you want to say something?
I was going to withdraw it. I tend to agree with this amendment. I'm reminded of the fact that significant percentage of the world fertilizer for anything other than food or for animals is illegal. But I tend to agree with the amendment.
Thank you. With that, I ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Prue,
Nope.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Gagny,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschanel,
Yes.
Representative Barry,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
and Chairman Roy.
Chair votes yes.
15-1.
15-1, motion carries. Any objection to consent? Nope. Oh, never mind. Any new motions? Yeah, with my bed. Any new motions?
Representative Murphy, do you have a motion?
I move auto pass as amended.
Thank you. Seconded by Representative Harry Gathright. Any new discussion, new insights in the last couple seconds? Seeing none, I would ask the clerk to call the roll. Motion on the floor is ought to pass as amendment.
Vice Chair Rhodes,
Yes.
Representative Prue,
No.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Gagny,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschanel,
Yes.
Representative Barry,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
and Chairman Roy.
Chair votes yes.
15-1.
15-1, motion carries. Any objection to consent? Seeing none, it'll go on consent. Representative Prue, I need a minority report by the end of the weekend. Yeah, I'm going to need one. And with that, I close the executive session. And I open the executive session on House Bill 57. Representative Muse, would you like to make a motion on that?
Yes, I would, Mr. Chair. I'd like to make a motion about to pass.
Seconded by Representative Murray. Would you like to speak to your motion?
This is a bill that was that I was actually asked to file by the Department of Corrections, and what it would do is it would change the parameters of alternative home confinement so that people who want to take secondary college courses in the or secondary post-education courses in the towns where they're confined are actually able to do that. So this is something that has potential, to be life-changing for people who basically are among the most qualified people to be eligible for release. So these are people who basically the Department of Corrections itself is willing to gamble on. These are folks that have been approved for alternative home confinement, and essentially these are folks who are either monitored directly by the department or who have some type of electronic monitoring device. They are only allowed to go outside their homes for things like employment opportunities and I believe public service jobs as well now. This would actually expand it to post-secondary educational opportunities. Where this can come up as a practical matter sometimes is if you look at places like the Portsmouth Naval Shipyard that's over near where I am. They have apprenticeship programs that actually require folks to work on site at the shipyard at times, but there are also courses that people are required to take as part of that over at Granite Community College. So not quite sure how many blended opportunities there are, but there's a really practical example of where a bill like this could really help could maybe be the difference between somebody being able to transition smoothly into life outside of prison and not be at risk to go back to prison versus maybe increasing that risk a little bit. So again, this was requested by the Department of Corrections, and I hope you'll support it.
Thank you, Representative. Would you like to speak to your second? Representative Murray.
Just to say that I definitely think we should be passing any legislation that can help reduce recidivism.
I agree. Any further discussion?
Actually, I have a question.
Yes, sir.
Is this for like online school only, or is it they can go out to a?
You would be able to do either. You would be able to go online, or you would be able to go out into the community. The thing is the way alternative home confinement works is you have to be back in your house by a specific time of the day. If you're not, you're in violation of your terms and they can take you back. This is something they already do. If you have, for instance, there's a job that you have outside. Currently, our statute only allows it for for employment or for uncompensated public service.
Okay.
So this would basically, give somebody the option to do something like, take a business course, take a course that's necessary for an apprenticeship, that type of thing.
Thank you, Representative Muse, and thank you, Chairman Roy.
No problem. Any further? Seeing none, I ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yep.
Representative Lascelles?
Yes.
Representative Devoyd?
Yes.
Representative Gagny?
Yes.
Representative Paquette?
Yes.
Representative Saborn Duchesnay?
Yes.
Representative Barry?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Shear?
Yes.
Chairman Roy?
Chair votes yes.
16-0.
16-0 unanimously passes. Any objection to consent? Seeing none, it goes on consent. And who actually made that? Representative Muse, if you could, by the end of the weekend, a report, please. And with that, thank you all very much. I want to just note that we are continuing on with the progress we made last year as far as the number of unanimously passed bills, regardless of the numbers on either side. So let's keep that up and we'll have a great year. Thank you. Thank you.